discounted, my lord. I have a bona fide claim of right because I have purchased from a, there is no dispute that this is a ceiling surplus land. It is a tea garden land, my lord. And lordship knows it, after the invocation of the 56 Act, large chunk of land of the tea garden was, my lord, acquired by the state. And my lord, my vendor is a tenant under the Act. So therefore, I have a bona fide right of claim that why government should not settle with my vendor or with me, since I have stepped into the shoes of my vendor. Secondly, my lord, this bona fide claim of right is an expression which has been explained by this honorable court in the Decas case. And my lord, therefore, whether a summary procedure can be invoked like Rule 18.2 to evict me, when bona fide claim of right is in. I am on that, my lord. Let my learned friend take the instruction whether it is ceiling surplus land or not, because in paragraph 7 we have clearly stated, my lord. At least come to paragraph 7 at page 7.
Page 7.
7. That the petitioner state and aver that notice dated is misconceived, as it has been issued under Rule 18.1 and 2 of the so-and-so, whereas it is apparent from the admitted facts that the land under so-and-so was ceiling surplus land. The land has been erroneously equated with government khas land. Ceiling surplus land is calculated in terms of the Assam Fixation of Ceiling Act, Holding Act 56, which came into force on so-and-so in all plain districts of Assam. The level of ceiling was 49 per acre plus allowable area for orchard up to so-and-so. It was applicable in agricultural land. The term agricultural land defined in the Act includes horticulture, agriculture, pisciculture, animal husbandry, and other allied purpose. Further, this ceiling limit was downgraded in subsequent years and on several occasions up to 16.33 acres of the land. The purpose of this act was not to collect land for government use or purpose, but for redistribution among landless agriculturalists and cultivators. As such, the present land was occupied by Nondo Beria, who was eligible to be settled with the said land, being poor landless cultivator himself. Later, occupancy right was sold to the present petitioners by his daughter, and here, as they were unable to cultivate the land, further due to their own financial condition, which is not prescribed in law. It is further stated it was never intent of the legislature to expand the meaning of the government house land under regulation to encompass the ceiling surplus land, as later term has different connotation and is intended to achieve a very different object specific to the act. But this being the background, my lord, can it not be said, my lord? At least an arguable case is there, my lord. So to say that this is a per se government house land, it may not be correct, my lord. And my lord, we have also dealt with how this land is to be distributed. That we have dealt with in paragraph 10. That the petitioner submits that there is a dispute raised over who is the tenant of the land in question by the said complaint, Jiten Kurmi, and without holding any inquiry in that regard, respondent number 3 hastily decided to eject the petitioner, demolish their shop, and hold all construction as being illegal encroachment. This despite clear judicial pronouncement holding that power of disposal of ceiling surplus land vests on the government under the Assam Fixation of Ceiling on Land Holding Act. Under Chapter 3 of the Ceiling Act, the cultivating tenant are the first category upon whom excess land can be settled under Section 16 of the Ceiling Act. When land is not settled with the cultivating tenant, government under Section 17 can give settlement to landless cultivators who are victims of natural calamities. In the present case, occupying cultivator tenant was the father of the vendor from whom the petitioner purchased their bona fide purchase area occupancy right, and has every right to be settled with the land in question, as the state has neither dispossessed him nor offered him compensation, nor had made him any offer to be settled with land in question being occupied in terms of Section 16(1)(b) of the Act. So this is my case, my lord. Therefore, I think, my lord, it's a matter which lordship would ideally like to go into, my lord. It can't be said that the issues are settled.
Okay. But
Lordship, may I say something?
yes.
The order impugned in this case, Lordship, is at page 23.
Just a minute. 23.
Page 23, Lord. May I read out?
Please.
This is to inform you that Moza so and so of government ceiling land covered by the Sogna being illegally occupied by constructing shop, etc. Therefore, within 15 days of notice issued under section 18A and section 18B of the Assam Land and Revenue Regulation, satisfactory reply may be submitted. It is only a so-called notice, Lord. It's not a demolition notice, Lord, or eviction notice. It is only a so-called notice issued on 28th of February, directing them to reply satisfactory. Without replying, they have approached this honorable court. Is it not a premature application, Lord? Had it been a demolition notice or eviction notice, the matter would have been different. But here they have challenged the notice whereby they have been so caused to reply. So this is the notice impugned, Lordship. Whether any interference
Have
by
you
this
filed
honorable
the
court,
reply?
No, my lord.
then Lord.
No, my lord, my learned friend is correct. That way it's a show cause notice. But our case is, my lord, the show cause notice is premised on the basis which eventually will lead to my, eviction, my. There is a bona fide claim of right. That right needs to be adjudicated. Or lordship may give a time frame.
Had it been an eviction notice, Lordship, I would not have uttered a single word, Lordship.
Okay.
Lordship can give a time frame, in which case my lord will approach.
Let us pause you. Part 3, K.N. Chaudhary, Learned Senior Counsel assisted by Sri N. Barwa for the petitioners. Full stop. The petitioners have put to challenge and our notice dated 28/2/2024 issued by the Circle Officer, Amguri Revenue Circle, under section yes. Under section under section A, under regulation 18 of the Assam Land and Revenue Regulation 1886. Full stop. It is the case of the petitioners that vide a sale deed, vide a deed dated 2/12/2021, the petitioners had purchased the possessory right from one Puran Bedia, a tenant. Full stop. It is contended that there is a dispute between the tenant, between the vendor of the petitioners and another party, which would be reflected by a complaint registered on behalf of lodged on behalf of the other party by one Jiten Kurmi, which had triggered into issuance of the impugned notice dated 28/2/2024. Full stop. It is further contended that the petitioners have applied under the Basundhara scheme for conversion of the land in question on the basis of their possession. Full stop. Para. Issue notice returnable on we'll have it on returnable on 8th of April. 3
For R1.
3 R. Pujari, Standing Council Revenue Department accepts notice on behalf of respondent number 1,
Myself 2 and 3.
whereas Sri H. Sharma, Learned Additional Senior Government Advocate Assam, accepts notice on behalf of respondent numbers 2 and 3. Para, let extra copies be served upon the Learned Council for the respondents by tomorrow. Full stop. Para. Sri Chaudhary, the learned senior counsel, prays for an interim order, full stop. It is submitted that Rule 18 of the so-and-so rules cannot be invoked as the land in question is a ceiling surplus land and there is a bona fide right of claim, full stop. It is argued that summary procedure cannot be invoked in a matter of this nature, full stop. He has also referred to the averments made in the writ petition regarding the nature of the land which is stated to be ceiling surplus and also the procedure which is to be adopted for dealing with such ceiling surplus land, full stop. Sri Borpujari, the learned counsel, the learned standing counsel revenue, however, has strenuously objected to the prayer for interim order, full stop. He, by referring to the sale deed, which has been annexed to the writ petition, comma, he submits that admittedly the land in question is Tawzi land, as would be evident from the schedule of the deed, full stop. He submits that even if it is assumed that the land in question is ceiling surplus land, comma, the same would be treated as government land, full stop, by referring to the Assam fixation of ceiling on Land Holdings Act 1956, more particularly Section 15 and Section 7 within brackets 4 thereof, comma, the standing council has submitted that such land vests upon the state government, and therefore there is no reason as to why the provisions of the regulation 18 would not be applicable. Full stop. Para. Supporting the objections of Sri Borpujari of the Learned Standing Council, Revenue Department, comma, Sri H. Sharma, Learned Senior Government Advocate, has submitted by referring to the impugned notice dated 28/2/2024, has submitted that by the said notice, comma, the petitioners are directed to show cause, and the same cannot be construed to be a notice for eviction per se without hearing the petitioners. Full stop. Para. After consideration of the rival submissions on the interim prayer, comma, this court is of a prima facie view that no interim order is called for at this stage, as apart from the substantial point sought to be urged, comma, the petitioners are yet to file their reply to the so-called notice dated 28/2/2024. Full stop. Therefore, while declining to grant any interim relief, comma, this court makes an observation that all actions taken pursuant to the impugned notice would be subject to the further orders that may be passed by this court. Full stop. The petitioners would be at liberty to file their reply to the notice within a period of a week from today. And in that event, the same would be considered in accordance with law and by giving an opportunity of hearing to the stakeholders.
Development.
29 controversy.
May please, Your Lord. My Lord, in fact, the petitioners are 13 in numbers and they have joined together, being facing, my Lord, identical cause of action and grievance as well. Now, what has happened, my Lord? The petitioner from 2002-5-6, my Lord, about more or less 20 years, they've been running business, my Lord, in the premise of the ASTC, my Lord, located at Paltan Bazaar. Now,
Yes.
at first, my Lord, at the outset, if your Lordship comes to page, my Lord, 39,
39.
39, my Lord,
Yes.
this is, my Lord, the allotment letter issued by the Managing Director of ASTC to petitioner number 1,
Yes.
Ujjwal Bhattacharya. Now, subject, allotment of a space measuring 7 into 10 at ASTC Paltan Bazar Station campus for running internet ticketing agency. Your application dated so and so. Now, before proceeding further, my Lord, recently, my Lord, in fact, the ASTC had issued notices, my Lord, saying that you are required to vacate the premise and all deeds, my Lord, are hereby terminated and you are treated as unauthorized occupant. And by the notices, my Lord, 13 February 24,
Page
page, my Lord, 96, my Lord, 30 days have been granted. So,
13.
30 days, page 96, my Lord.
13 February.
13 February, there are a series of, my Lord, notices, identical notices issued to the
96.
page 96.
Okay. Notice for vacating.
Vacating, my Lord. To hand over, my Lord, the possession. I'll come here later on, my Lord.
Yes.
Now, if your Lordship again comes back to 39,
Yes, please.
this is the allotment letter. It reads as follows, my Lord. With reference to the above, I am to inform you that the STC authority is pleased to allot a space measuring 7 into 10 feet, 70 square feet, for running a internet ticketing agency at STC station campus, Paltan Bazar, subject to the following terms and conditions. The rent, Lordship will take note of, my Lord. The rent is fixed at the rate 1500 only per month, excluding the electricity charges. The monthly rent has to be deposited by you to the DMASTC Guwahati in every first week of each month. The rent will be effected from 1 to 2006. So monthly rent, my Lord, at the rate of 1500. Thereafter, 2, my Lord, for allotment of the space, you will have to deposit an amount of 30,000 at HO as registration fee, which is non-refundable.
Okay.
Number 3, the construction of the room will be done by you at your own cost by RCC structure with CI sheet roofing. The construction cost as advance rent subject to the maximum of 70,000 only, which will be adjusted 25% of the rent and 75% of the monthly rent will be paid in cash.
Assam Urban Areas Land Control Act. হালদিয়া খনৰ নীলা খন Yes.
My Lord, serial number 3, my Lord, your Lordship has already seen. Construction of the room will be done by you at your own
Yes,
cost
yes,
by
we
RCC.
have seen that.
Yes. Number 4, the rent will be revised after 3 years interval. This is not a temporary, my Lord, arrangement. Now 5 says, you have to vacate the said space if it is required by ASTC own use within 1 month notice. So on own use, my Lord, the ASTC, my Lord, will issue a notice. My Lord. Then, my Lord, 6 says you have to enter into an agreement. Now, similar, my Lord, allotment letters have been issued to other petitioners. I will draw, my Lord, 2, 3, my Lord, and I will proceed further.
If those are similar, why are you referring?
No, in fact, I want to show that by other notices, my Lord, in fact, there is a construction of 2-story, 3-story building also, my lord. There are, my lord, in fact, hotels, restaurant, my lord, what is being run, my lord, mobile, ASTC online shop, restaurant, courier cargo, my lord, business of tire, battery, fast food, hotel, etc. These, my lord, are being run in the premises, my lord.
By you.
Yes, by the petitioners, my lord. And there are two, my lord, storage building is existing, my lord. That will be,
Okay. Yes.
now, my lord, my first submission is, having regard to these letters, my lord, the STC intended, my lord, to create a list. Thereby, my lord, rent has been collected. There is provision of monthly rent.
Yes, yes.
There are permanent structures, my lord. Yes. So therefore, in that view of the matter, my lord, the provisions of the Urban Rent Control Act 1972 will apply. Now, your lordship is aware that the land belonging to, my lord, ASTC is not a government land, and the division bench of this honorable court has settled it in a PIL, my lord, Saras Chandra Kingho's case, that the ASTC is entitled to transfer, sell, lease out its land, my lord. So therefore, in the present case, my lord, ASTC is a landlord and the petitioners, my lord, are tenant.
Yes.
Rent Control Act. So under the 1972 Act, my lord, the definitions are there. The Act will apply where, my lord,
Yes.
is made clear. There is definition of landlord, tenant, my lord, pakka structures, rent, etc.
Hmm.
Having regard to that, my submission is, my lord, in view of the application of this, my lord, Act, the provisions of this Act, the recovery of possession, my lord, has to be made under Section 5. And when there is a bona fide requirement, Section 5(1)(c), my lord, will apply.
Yeah. Okay.
Now, my lord, my submission is that 5 says that a decree has to be obtained, my lord, by the, my lord, civil court. So in the present case, my lord, the notice which is, my lord, issued by the ASTC, my lord, there is neither a requirement under the Urban Rent Control Act. Notice is not required. This honorable court has held, my lord. The requirement under 106 TP Act will not apply where the Rent Control Act, my lord, applies. Your lordship is aware. So on that count, the notice, my lord, is bad, is not tenable because there is no requirement under this Act. And secondly, my lord, the respondent ASTC has misconstrued, my lord, the provisions of law. And thereby, if a submission comes in, my lord, that this is a notice, my lord, and we will not evict, my lord, that because when the ASTC misconstrues, my lord, the law, tomorrow when, my lord, 1 month expires, they may, my lord, exert force on us. Therefore, my lord, we are before your lordship, my lord. Now, if the ASTC says that if we will take recourse, my lord, to provisions of law, my lord, we have nothing to say. Now, the question is, when there is an expiry, my lord, of the lease, now, my lord, the rent, my lord, is not accepted by them, and the lease, my lord, is not extended. What is our position, my lord? At present, my lord, our position is as a tenant at sufferance. We are not, my lord, we are not legally holding the possession, my lord, but our possession is juridical, meaning thereby that recovery can be done only by a judicial proceeding. So in this case, my lord, I place one judgment of the Supreme Court where the tenant at sufferance, my lord, has been discussed. RB Bhopal's case, my lord. This case has been, my lord, relied on 1995 5 SCC, my lord, 698.
1995?
5 SCC 698. This case was relating to license, my lord, of a cinema hall. Now, during the course of the adjudication, my lord, the Honorable Supreme Court, Para 8, my lord, this has been discussed by the Supreme Court.
Yes.
Tenant at sufferance is one who comes into possession of land by lawful title, but who holds it by wrong after the termination of the term or expiry of the lease by efflux of time. The tenant at sufferance is therefore one who wrongfully continues in possession after the extinction of lawful title. There is little difference between him and a trespasser. In Muller's transfer of property at page 63, the position of tenancy at sufferance has been stated thus. A tenancy at sufferance is merely a fiction to avoid continuance in possession operating as a trespass. It has been described at the least and lowest interest which can be substituted in reality. It therefore cannot be created by contrast and arises only in implication of law. When a person who has been in possession under a lawful title continues in possession after the title has been determined with the consent of the person entitled.
Without the consent,
My lord.
not with the.
Without, my lord. Without consent of the person, correct, my lord, entitled. A tenancy at sufferance does not create the relationship of landlord and tenant. At page 769, it is stated regarding the right of a tenant holding over does, the act of holding over after the expiry of the term does not necessarily create a tenancy of any kind. If the lessee remain in possession after the determination of the term, the common rule law is that he is a tenant on sufferance. The expression holding over is used in the sense of retaining possession. A distinction should be drawn between a tenant continuing in possession after the determination of the lease without the consent of the landlord and a tenant doing so with the landlord's consent. The former is called a tenant by sufferance in the language of the English law, and the latter class is tenant is called a tenant holding over a tenant at will. The lessee holding over with the consent of the lessor is in a better position than a mere tenant at will. The tenancy on sufferance is converted into a tenancy at will by the assent of the landlord. But the relationship of the landlord and the tenant is not established until the rent was paid and accepted. The assent of the landlord to the continuance of the tenancy after the determination of the tenancy would create a new tenancy. Now, my lord, this is important. The possession of a tenant who has ceased to be a tenant is protected by law. Although he may have no right to continue in possession after the termination of the tenancy, his possession is juridical. Juridical means, my lord, that has to be determined by a, my lord, decree or a judicial determination. So, assuming, my lord, as on day, my lord, I am a unlawful, my lord, I am holding the possession unlawfully, but my entry was lawful, my lord. It was allotted to me. Rent was accepted. Permanent structure, my lord, is constructed, my lord, thereon. So, by way of a notice, saying that now you hand over the possession and then you go out. In my respectful submission, my lord, that cannot be permissible, my lord. Secondly, my lord, if your lordship comes to the subsequent extensions, my lord, your lordship will find that the deeds are being converted into license. Now, once, my lord, a lease is created without, my lord, determination of that lease was not determined, my lord. It was extended from time to time, and it has been converted to license. Your lordship is aware, my lord, we are petty shopkeepers. We don't have any bargaining power with the mighty state. My lord, the format which has been supplied to us, my lord, we have put our signatures thereon, my lord. My humble submission, the subsequent document, where, my lord, it has been converted to a license, my lord, cannot change the original character of the lease, my lord.
When was the conversion done?
My lord, this was done from time to time. Your lordship will find
First
this.
conversion? First conversion?
My lord, that was, I have annexed, my lord, so far as the first allotment letter is concerned.
Yes.
In relation to that, your lordship will find at page 63.
63.
Yes. And this cannot be, my lord, termed as a determination of the lease. At best, my lord, it is a holding over. Because they have accepted our rent. They have permitted to operate, my lord.
63.
Page 63. It's a holding over of the lease, my lord, the possession. And here, my lord, it is converted to license, my lord. License, licensee, licensor, my lord, these terms are, my lord, used.
Yes.
My lord, my humble submission is, I may not hold on to this argument. Having regard to the proposition, my lord, in terms of the, my lord, Olga Telly's case, your lordship is aware, Constitution Bench has held that right to livelihood, my lord, is a part of, my lord, Article 21. So, my lord, the state, if it balances the equities, my lord, it must also consider or apply. At this stage, my lord, where will we go? You have allowed us, my lord, and we have changed our position to a detriment for last 20 years. My lord. Now, without any alternative source of, my lord, income, My lord, we come to the.
No, your submission that you have altered your position to your detriment.
My lord,
That may
No,
not be an acceptable.
that may not be accepted.
You
but
are doing business.
I'm doing, correct, my lord.
You are
but-
one of the very selected few who got the opportunity or
Yes.
rather a chance without any, there being a due process of law.
Well,
You
let
got
us-
the allotment. There were
let me-
thousands and thousands. Nobody got the allotment. You got the allotment.
My lord, we got
You
the
enjoyed for
allotment.
continuous for
We
20
got the
years.
allotment because as we got the allotment
From
there.
14, your first submission is a very acceptable submission if the position was continuing.
Right.
You, on your own volition, you entered the entire scheme was changed into a license from 2014, more than a decade back. We have seen 14 to 17, 17 to again extension. You never raised an objection.
My lord, in fact, they have.
So far as the other submission is concerned regarding framing of a scheme for your rehabilitation kind of, if you are bringing in the concept of Olga Tellis will not come in. Those were payment dwellers.
Correct, my lord. But
You-
what
you-
I'm
you
drawing
were-
the analogy, my livelihood, my lord, is part
You
of Article
cannot
21.
equate yourself with the masses in the
No,
payment
correct, that
dweller
is
of
correct.
Bombay who by a means of a PIL.
I'm only bringing in the analogy, my lord, the proposition of law.
Depends what the learned AG
My lord,
say,
yes.
whether they are thinking over of anything.
In fact, what I'm trying to say,
But your conduct and your entry and 2014, the change of the scheme and presently the lease which you are trying to bring in and the argument may not be very relevant.
my lord, in fact, your lordship will see, my lord, I may bring in, my lord, the principle of holding over. They have allowed me to continue.
As a
Lease was created.
as a licensee.
My lord, licensee, my lord, they cannot change that because there was no determination, because your lordship will see, there was no notice at all.
Mr. Talukdar,
Yes.
the argument of yours should have been made in 14, 15, 16,
Correct, that
17.
is correct, my lord. That is
Only
correct. But your lordship will also consider
You,
our
by your
bargaining
by
power
your-
with the
by-
state.
By your own conduct, you have acquiesced. You have said that yes, license is okay. Now there is a need. Is there any mala fide involved? Number
No, my
one.
lord, I'm
The
not on
first
that.
question.
Absolutely not on that.
Whether it is on public
Yes,
interest.
I'm also, my lord, conceding to this fact, my lord, that your lordship will definitely balance the equity. My lord, there are other premises, but I'm
Mr.
again
Saikia,
submitting.
are you thinking of any, any other?
There is no such proposal.
No proposal. What yesterday, if you remember correctly, he said you have space in Khanapara and some
He
other.
was saying, but
That's not possible.
that is not possible. If that, we have to follow Article 14 and 16, as Lordship has indicated that also. Cannot choose some blue-eyed person.
There
They
are
have
four,
been,
In case, but
they have
that
been
is,
running
that is
their-
also not there.
They have been depending on this for a long period. Can you think over anything?
four premises, my lord. Khanapara, ISBT, Ulubari, Volvo, and in the present site also, 2 bighas, my
No,
lord, has been.
obviously, they will not get anything extra than any other person. They have to be.
Now, what we allowed them to have these outlets for the interest of the passengers.
Correct.
Our purpose was for passenger, and there is no bus operating now from there. I'll argue once my learned.
But this, Mr. Talukdar, this space which was primarily meant to facilitate the running of the buses and the commuters, passengers, you are having battery shops. Why?
Required for the STC buses.
And they'll not buy battery from you. These are all ASTC buses. They'll have government supplies. What did you mention? Battery shops. Some
Yes, my
other.
lord, there are, in fact, I have mentioned the restaurant, the courier cargo, that which are, my lord, the transit of those, my lord.
No, then
Yes.
2, 3
Then,
more.
yes, business, fast food, stationery shop,
Okay.
everything, my lord.
No, this
Mobile repairing,
mobile repairing. Okay.
ASTC online shop, my lord. The ticket,
Battery.
battery, yes, battery is also there. It appears from the materials on record. This is required, that is why, my lord, they have allowed. Otherwise, they would not have, my lord.
See, even if you argue or do not argue by or any other side, this space is primarily meant to help the passengers or the corporation. The business has to have some relation. Restaurant is okay, courier is okay. These others, but okay, yes. Anything else?
My lord, in fact, no. Basically, my lord, this is my humble submission, my lord. Because on the basis of the materials on record, I cannot develop my case. But at least having regard to the fact that for last 20 years, we are catering to the need of the.
Have you applied
passenger.
for giving any other space?
We have submitted a representation, my lord.
Where?
Yeah, that is the part of the report, my lord.
Where?
Your lordship will find at page, my lord, 125. We have submitted to the managing director.
125.
Yes, 125, my lord. On 19/2/24, this has been, my lord, acknowledged, received also, my lord. Page 125.
Yes.
So this is also pending before the, my lord, managing director.
Yes. Yes, Mr. Saikia.
He was also running saloon, lordship,
Passengers might need a
a
separate.
freeze shop, inverter shop, mobile handset. Anyway, I am not on that lordship. We have to give up this land to the NF Railway lordship. In exchange of a plot of land we are getting in Jalukbari, where we are going to have the bus terminal. So
That bus terminus land is of railways.
some land will be given there
Of railways.
of railways.
Oh.
We are giving here about 2 bighas or 3 bighas. We'll get 4 bighas, and we'll getting much more land in Jalukbari point. The exchange offer. Because our bus stand, we have already shifted it to lordship knows that national highway,
ISBT.
ISP. So the notice
And this area, Jalukbari, would be for what purpose?
for bus
Bus
terminal.
bus terminus.
Bus terminal. In fact, in one of the PL we have made this submission also. Page 38, Lord. One of the argument is that, Lord, they are saying that they have invested money for construction. That has already been adjusted. If Lordship is pleased to look at page 38, the notice, the first allotment order. For allotment, paragraph number 8. For allotment, you will have to deposit an amount of 30,000. Then 9, the construction of the room will be done by you at your own cost by RCC structure with CIC roofing. The construction cost as advance rent subject to maximum of 70,000, which will be adjusted 25% of the rent and 75% of the monthly rent will be paid in cash. So that amount was already adjusted. Whatever they have invested up to a maximum amount of 70,000 in 2005, it was a part of adjustment in the rentals.
Rentals.
Now, next is you have to vacate the said note space if required by a own use within 1 month's notice. So this is precisely what we are doing here. The impugn notice is for this purpose. You will have to enter into an agreement. Here we have not mentioned either lease or license. You will have to enter into an agreement with ACC and yourself and non-judicial stamp paper, etc. So this was a part of that. And in respect to that, Lordship, page 63, the license was executed in 2014, and Lordship has rightly observed 3 years period initially from 1/4/2014 to 31/2017. Now this deed of license witness as follows, page 63. Here serial number, the recital number 7 and 10.
Page.
Page 63, it starts.
Yes.
It starts, it's a license, deed of license at the top.
Yes.
And before serial number 1 also. Therefore, this deed of license witnesses as follows. 1, 2, 3, 4, that way. Number 7 is relevant for our purpose.
Yes.
That it is also agreed by both the parties. So it is an agreement by both the parties that if in any case the said premise, space, stall, shop is required by the licensor for the purpose of own use during the period under this deed of license, the licensee shall vacate the same provided 1 month's previous notice shall be required to be served upon the licensee by the licensor. Then that it is clearly stated, defined and understood by both the parties that execution of this deed of license in no case confer any right or interest or on the demise in the aforesaid premise more fully described in Schedule A below in favor of the licensee except physical possession as is necessary for carrying on the business of the said shop stall as agreed upon under this deed of license. So in very categorical terms, this agreement was signed and executed without any coercion. And with their eyes wide open, they have entered into this agreement. And in terms of that particular clause in the allotment letter at serial number 11, we issued the impugn notice. Let us see the impugn notice,
Page?
Lordship, page 96. 13th February 2024. Please take notice that allotment order dated 17/12/2005 issued by ASTC. The schedule premise for running business in the name of Ujjwal Bhattacharya is as described herein below was allotted to you in lieu of paying monthly rent at the rate of 1,500 rupees per month for carrying on the business of internet ticketing agency at ASTC, Polton Bazar, Guwahati. Accordingly, you are in occupation of the scheduled premise, thereby carrying on the business of mobile repairing shop and ASTC online ticket booking counter. Now, pursuant to a cabinet decision dated 8/5/2023, the government of Assam has decided to deliver the land owned by ASTC at Polton Bazar, Guwahati, measuring 4 bighas, 4 kathas, 19 lessers, covered by DAG number 554555, to the Northeast Frontier Railways for the purpose of construction of second entry of Guwahati Railway Station. Pertinently, the scheduled premise which you are occupying is comprised within the said land. Under the aforementioned circumstances, allotment of the scheduled premise granted in your favor is hereby cancelled with immediate effect. You are therefore asked to vacate the scheduled premise and deliver peaceful and vacant possession of the same to ASTC within 30 days from today. You are also asked to pay the sum of 3,314 only, excluding electricity bill to AC, being the outstanding monthly rents in respect of the scheduled property. Pertinently, as per clause 5 of the aforesaid allotment order dated 17/12/2015, you will have to vacate the said space if it is required by ASTC for its own use within 1 month's notice. In the event you fail to adhere to the demand made in this termination and eviction notice, the ASTC authorities will initiate appropriate legal action against you at your own risk and peril. Please treat this as a termination notice with immediate effect. Moreover, the period of agreement between ASTC and you is over, and any occupation of the scheduled premise with effect from 13/2, that is from 13/12, coming day after tomorrow, by you will be treated as unauthorized occupation. So we have given him the fair chance to vacate it. And all these things are done as per the terms of the allotment as well as the license deed. He is also a defaulter. It is very clearly evident. Others are also heavily defaulting in payment. But that I am not arguing. So now, in my humble submission, what we are saying that if we do not vacate it, then appropriate legal action will be taken as per the existing law. So which act we are going to apply? It's a subject matter of the subsequent development. At this stage, we are not saying whether the Assam Public Premises Act of 1971 will come into, or the, according to his argument, the Urban Rent Control Act of 1972 will be applied. That decision we are yet to take. And in his pleading, there is no such averment that which law will be applicable. So it is not a notice under any of the statutes. It is a notice under the condition stated in the allotment order itself. So my humble submission is that his writ petition is premature in nature unless he is only challenging the termination order. But so far as eviction part is concerned, Lordship, we are going to take appropriate action at the relevant. If he decides not to vacate it by tomorrow, then from 14, the cause of action will arise for ASTC to start a proceeding. What proceeding, under which statute, we'll take a call on that, but not today. For that purpose, if he vacates, some of them will vacate. So no cause of action will arise. But whoever are not abiding by this notice, in that situation, Lordship, we will have to take recourse of the relevant laws. So whether 72's Rent Control Act or any other civil suits or the Public Premises Act of 1971, that will come into play, we do not know at this stage, and we are not committing also. But prima facie, I have to tell this honorable court, the Assam Public Premises Act is straightway applicable to this case. Assam Public Premises Eviction of Unauthorized Occupants Act 1971. So
Just-
till tomorrow, he is authorized occupant. We are allowing him to occupy till 13th February. On 14th February, Lordship, this act will be applicable. On 14th, he will be unauthorized occupant. So that cause of action has not arisen till now. There is no discrepancy or no ambiguity regarding the public premises. Under this act, the public premises is defined is like this. Section 2, subsection C. Public premise means any premise belonging to or taken on lease, hire or requisition by or on behalf of the state government, the Assam State Electricity Board, the Assam State Road Transport Corporation, or any other public sector undertaking owned or sponsored by the state government. So the definition squarely covers ASTC's property. So there will be no ambiguity regarding the application of statute in case we have to go to that third decision of starting a proceedings for evicting them. We want that the relationship should be good so that they vacate us in case if any opportunity comes up, if I am not committing anything, they will have to be given some additional advantage. Maybe I do not know at this stage, past experience or past relationship with ASTC, but that is a future event, Lordship, which is not fructifying at this stage. So the law is very clear, Lordship, and whatever we are doing is in terms of the various allotment orders and the deed of license, which he also executed with ASTC. So there is no arbitrariness, malafide intention or anything like this. We are not pushing him out of the ASTC campus and giving it to some other blue-eyed person. It is not a case. It is for general public interest. There will be a second entrance to the NF Railways, Polton railway station. And in lieu of that, ASTC is also gaining some land in the outskirts for having bus terminals. Although in our affidavit, we have not indicated that, but for the purpose of railway second entry, Lordship, that is stated. If Lordship is pleased to take up my affidavit, paragraph 3, because my learned friend on the earlier occasion was arguing that it is a notice under the Assam Public Premises Act of 1971. So that today that argument is not put forward. So
Your affidavit,
affidavit filed by Mayuri Kolita, respondent number 3, 4, and 5.
yes.
So
Which paragraph?
paragraph 3, we say the writ petition is premature and no cause of action has arisen. Then paragraph 6,
Just a minute. Paragraph 3.
paragraph 3, it is a premature hour stand, and paragraph 6, that they were allotted it. Paragraph 7, may I read it, Lordship? The answering deponent begs to state that the same are not born out of various allotment. The same are born out of various allotment orders issued by ASTC to the petitioner. In this regard, it is stated that the various allotment orders annexure B collie of the writ petition stipulated the allotee, that is the petitioner concerned, shall vacate the land allotted space within 1 month's notice if it is required by ASTC. In this regard, for instance, the answering deponent begs to refer to clause 11 of the allotment order dated 17/12/2005 pertaining to the petitioner number 1 at page 38 of the writ petition. In next paragraph, Lordship, paragraph 6, we have also mentioned about the license and the clauses of license. In the last 2 lines, in this regard, for instance, the answering deponent begs to refer to clause 7 and 10 of the deed of license dated 28 June 2014 pertaining to the petitioner number 1 at page 64 of the writ petition. So I have already placed the 2 clauses. Paragraph 9, Lordship. The answering deponent begs to state that pursuant to a cabinet decision of 8 May 2023, the government of Assam has decided to deliver the land owned by ASTC at Polton Bazar, Guwahati, measuring 4 bighas, 4 kathas, 19 lessas, covered by Dock number 554555 to the NF Railway for the purpose of construction of second entry of Guwahati Railway Station. Accordingly, individual termination and eviction notices dated 13/2/2024 were issued by the ASCC to the petitioners and other allottees, whereby and whereunder the allotments of the scheduled premises granted in favor of were cancelled with immediate effect. Moreover, the petitioners and other allottees were asked to vacate the scheduled premises and deliver peaceful and vacant possession of the same to ASCC within 30 days, with effect from 13th February to 2024. Further, the petitioner and other allottees were also asked to pay the outstanding dues in respect of the scheduled premises to ASCC authority. In this regard, the petitioners and other allottees were informed that in the event they fail to adhere to the demand made in the termination and eviction notice dated 13th February, the ASCC authorities will initiate appropriate legal action against them at their own risk and cost. The petitioners and other allottees were also informed to treat the matter as termination notice with immediate effect. Moreover, the period of agreement between ASCC and petitioner and other allottees is over, and in any occupation of a scheduled property with effect from 13th February by them, it should be 13th March, by them will be treated as unauthorized occupation. In this regard, for instance, the answering deponent begs to refer to termination and eviction notice dated 13th February pertaining to petitioner 1 at case number so and so.
Okay.
Paragraph 11, last 3 lines. In their writ petition, they said that they are all senior citizens. I have found that some of them are 27 years old also. It is specifically denied that most of the petitioners are now aged between 50 to 68, having children and old age parents, and at this stage they have no alternative scope to go for any other employment. In this regard, it is stated that ASCC authority had allotted spaces to the petitioners and other allottees for the purpose of catering to the needs of the passengers and commuters of ASCC Polton Bazar station at Guwahati. It is stated and submitted an action of the ASCC culminating of issuance of the termination and eviction notice of 13th February is in accordance with law and in greater public interest. It is also stated and submitted that it is for the ASCC authorities to decide how to utilize their land, and the petitioners cannot impose and dictate their terms and conditions in this regard. So indirectly, we are saying that it is not possible at this case to give any commitment for their resettlement. So that option, in my humble submission, is not open, because we do not know where there will be some rooms or not in the other places. So we do not want to give any vague assurance also. So whatever we are doing, it is as per the terms and conditions of the various agreements and allotment orders, and nothing illegal has been done. There is no violation of any law. There is no malafide action. There is no biasness. There is no favoritism. And in that view of the matter, Lordship, this is a fit case for this is my humble submission.
Well, may I give a short reply? Firstly, my lord, I have made it clear with my submission that we are not challenging, my lord, the proposal, my lord, for a second entry point. There is no challenge, my lord, to the decision also. The question of, my lord, malafide, etc. does not come. My lord, our submission is only with regard to this fact, my lord, that being a state, an instrumentality of the state, my lord, it is duty bound, my lord, in fact, to deal in a fair and reasonable manner. And being a constitutional court, your lordship will, my lord, please to balance the equities, my lord. In that regard, my lord, we have approached your lordships, my lord. Now, so far as, my lord, the submission of, my lord, my senior learned advocate general is concerned, my lord, even if, my lord, the 71 Act applies, even if 71 Act applies, my lord, then also, my lord, we will have to have an opportunity, my lord, of affording an opportunity of hearing. They have to hear us. And in that, my lord, even our representation, personal hearing has to be there. On that count also, my lord. 71, my lord, even if 71 applies, my lord, I am not conceding to that, my lord, argument. I am on, my lord, that here is a case where 72 Act applies.
Yes.
Now, if the relevant statute, my lord, does not provide for any notice, and if, my lord, the ASTC and the state is, my lord, proposing to, my lord, proceed in accordance with law, then this notice, my lord, is not tenable. If there is no requirement under the law, because eventually, if my lord, law is required to be taken recourse to, my lord, this notice, my lord, has no force in the eye of law. That is why, my lord, we approached your lordship, my lord, that tomorrow, in the garb of this notice, my lord, we may be evicted. And if, my lord, the assurance comes that we will not be evicted without, my lord, in accordance with the procedure established by law, we have nothing to say. If, my lord, civil court is, my lord, approached, or, my lord, either of the two statutes, my lord, is taken recourse to, my lord, as my learned senior, my lord, has submitted, that we have nothing to say, my lord. So, being, my lord, facing a threatened, my lord, eviction, we have approached your lordship, my lord. I again, my lord, say that let the ASTC take a call, because they have not even considered whether we can be accommodated or not. Because the argument is, my lord, that state is not aware whether we can be, my lord, accommodated or not. That call has not been taken, not considered, my lord. Let them take a, my lord, decision, because we are continuing, my lord, for the last 20 years. And there is no, my lord, question of violation of Article 14 also. Because we stand, my lord, separately on different footing, my lord. We are continuing there. Secondly, my lord, so far as the allotment letter is concerned, though it does not speak about license or lease, my lord, your lordship will go by the substance, my lord. Rent having been accepted, permanent structures having been constructed, we are tenants, my lord. So therefore, it has to be understood that this was a lease, my lord. The form, my lord, cannot have precedence over the substance, my lord, in my respectful submission. Secondly, my lord, the conversion of, my lord, the lease to license in 2014, my humble submission, the principle or doctrine of holding over will come in, my lord. 116 of Transfer of Property Act. You have accepted, there is a tacit approval on your part. You have allowed us to continue. You accepted the rent. Now you cannot change the character of the lease. This is a holding over, my lord. So therefore, my lord, my humble submission, the initial, my lord, lease will, my lord, continue to operate. Thirdly, my lord, we have put our signature. It is absolutely correct. But your lordship will also take note of that our bargaining power
That
with
you
the
have argued,
STC.
that you have argued.
Yes. So therefore, my lord, to run our business, we have acceded to that proposal. Lordship will only consider our plight, and my lord, direct the responding authorities at least to consider, my lord, how to accommodate us, my lord, in either of these four places, my lord. And until then, my lord, lordship will say, my lord, status quo shall be maintained. This is my humble submission.
Okay, right. Certain numbers of petitioners have approached this court challenging inter alia notices dated 13 February 2024 issued by the chief engineer within bracket civil ASTC being the authorized signatory directing informing that the allotment of the scheduled premises to the respective petitioners were cancelled with immediate effect, and they were directed to vacate the scheduled premises and deliver peaceful vacant possession to the ASTC within 30 days. Full stop. The petitioners were also directed, a few of the petitioners were also directed to pay certain outstanding dues to the petitioner, to the ASTC. Full stop. Para. I have heard Sri S.K. Taludar, learned counsel for the petitioners. Full stop. The ASTC as well as the state respondents are represented by the learned Advocate General Sri D. Saikia, assisted by Ms.
Rajiv Borpujari.
By Sri R. Borpujari. You are also there, madam? Okay. full stop. Sri Saikya, the learned AG, has also referred to the affidavit in opposition filed on 5/3/2024. Full stop, para. Unfolding his submissions, comma, 3. Talukdar, the learned counsel for the petitioners, has submitted that the petitioners are running their business for the last about 20 years in the premises of the ASTC at Polton Bazaar. Full stop. In this connection, comma, he has referred to the allotment letters to the petitioners, and one such allotment in respect of the petitioner number 1 is dated 17/12/2005. Full stop. It is submitted that the said allotment order or allotment letter envisages payment of monthly rent, construction of a room to run the business, comma, revision of rent, full stop. The allotment order also contains a clause that if the space is required by the ASTC, comma, the same has to be vacated with a month's notice. Full stop. It is submitted that different businesses were run by the petitioners in the space allotted to them by constructing structures which even includes two-storied building. Full stop. The learned counsel submits that the land of the ESTC cannot be termed as a government land, and existence of the lease makes the ESTC a landlord within the meaning of the Urban Areas Rent Control Act, 1972. Full stop. Para. By referring to the provisions of the Act of 1972, comma, the learned counsel has submitted that though there is no requirement of a notice to vacate, unlike Section 106 of the Transfer of Property Act, comma, certain protections are given to a tenant against illegal eviction, which are included in Section 5 of the Act. Full stop. It is submitted that unless the preconditions laid down therein are proved in an appropriate proceedings, comma, a tenant cannot be evicted without a valid decree from a competent civil court. Full stop. Para. With regard to the issue of the lease not being extended, comma, the learned counsel for the petitioners has submitted that though the lease was not extended, comma, the position of the petitioners would be tenants at sufferance, inverted comma. Full stop. In this connection, comma, the learned counsel has referred to the case law of R.V. Bhupal Prasad versus so-and-so, reported in 1995, 5 SCC 698, wherein it has been laid down that even for tenants at sufferance, comma, certain rights would accrue upon such parties, and they cannot be evicted without following the due process of law. And by mere completion of a period of lease would not automatically equate such tenants to be illegal trespassers. Full stop. Para. It is reiterated that the entry into the premises was lawful by a valid deed, and it is only a matter of convenience that the lease was converted into license, which would not otherwise change the nature and character of the landlord-tenant relationship between the parties. Full stop. It is also submitted that the petitioners, who are petty businessmen, were not at par so far as the bargaining power with the ASTC is concerned, and therefore they had agreed upon conversion of the lease into license. Full stop. The Learned Council has also submitted that there are other space of the ASTC that has also submitted that if at all the space in question is required for public interest, comma, there are other space of the ASTC where the petitioners can be accommodated as they are running their business and their livelihood for a long period of time. Full stop. The Learned Council has referred to the representation dated 19/2/2024, which is pending consideration. Full stop. Para. Per contra, comma, the Learned AG has submitted that the present case is a prematured one, and there is no cause of action has arisen. Full stop. He submits that it is a matter of overwhelming public interest for which the present action is being taken, as the plot of land in question is being exchanged with the NF Railway for a plot of land at Jalukbari, wherein a bus terminus would be constructed. Full stop. It is submitted that the present plot of land would be made as a second entry point to the Guwahati railway station, and therefore there is immense involvement of public importance, mainly the commuters and the passengers. Full stop. Para. It is submitted by the Learned AG that it cannot be said that there is any relationship of landlord and tenant, as even the initial allotment letters cannot be treated as lease, inasmuch as the said allotment were given only on some exceptional circumstances to facilitate the passengers using the space for alighting, using the space for their journey by the ASTC. Full stop. By referring to the initial allotment orders, comma, the Learned AG has submitted that so far as the aspect of investment is concerned, comma, the same was to be adjusted with the monthly rentals and has in fact already been done, and therefore that issue will not be a relevant issue for consideration. Full stop. Clause 5 of the allotment order specifically states that the ASTC that the allottee would be required to vacate the space if the ASTC requires the same for its own use within a period of a month. Full stop. Para. It is the submission on behalf of the respondents that in any case, the arrangement was made into one in the form of a license from the year 2014, wherein a similar clause for vacating was there, full stop. By referring to the license, more particularly clause 7 thereof, comma, the learned AG has submitted that the allottee, the licensor, no, the licensee would have to vacate the premises in case the space is required by the licensor, and such vacation has to be within a period of 1 month from the date of issuance of notice. Full stop. Under clause 10, it has been specifically laid down that no right or interest would confer upon the licensee by the said license. Full stop. Para. By referring to the impugned notice dated 13/2/2024, comma, the learned AG has submitted that the said notices have been issued in terms of the clause of the license and not under any statute presently. Full stop.
Tenants and allotment order. Under the provisions of clause and the allotment order.
Under provisions of the allotment order and the clause of the license. Full stop. In any case, comma, by dealing with the submissions that the public premises, Assam public premises Eviction of Unauthorized Occupants Act 1971, which has been argued on the behalf of the petitioners to be not applicable, comma, the learned AG, by referring to section 2C, has pointed out that the definition of public premises includes the ASTC. Full stop. However, he clarifies that that aspect did not be gone into, as till now, no action under any statute has been taken. Full stop. It is reiterated that the action is not vitiated by any mala fide, as no third party has been sought to be, no individual third party has been sought to be favored, and it is only in the greater interest of the public that the action has been taken. Full stop. By referring to the affidavit in opposition dated 5/3/2024, comma, the learned AG has drawn the attention of this court to the relevant paragraphs, namely paragraph 3, 7, 9, and 11, to substantiate his contentions. Full stop. Para. Sri Talukdar, the learned counsel for the petitioners, in his rejoinder has submitted that so far as the action of creating a second entry point to the Guwahati railway station is concerned, by allotting the space to the railways in exchange of another plot of land is concerned, comma, there is no challenge as such, and therefore and therefore the petitioners have also not taken up the issue of involvement of any mala fide. Full stop. It is, however, submitted that the ASTC, being an instrumentality of the state, the petitioners are required to be dealt in a fair and reasonable manner by which their means of livelihood would not be adversely affected. Full stop. It is submitted that this court, in exercise of its extraordinary powers, would balance the equities and may direct the authorities to consider the cases of the petitioners. Full stop. He submits that even if it is assumed that the Act of 1971 applies, the same also envisages providing of an opportunity to an affected party, and a vacation cannot be done forcefully. Full stop. Para. The rival submissions advanced have been carefully considered, and the materials placed before this court have been scrutinized. Full stop. Para. And it appears that initially the petitioners were issued allotment letters, and one such allotment letter, so far as the petition number 1 is concerned, is dated 17/12/2005. Full stop. On a bare perusal of such allotment letters, it appears that a relationship of landlord and tenant would appear. Full stop. However, at the same time, there is a clause which empowers the ASTC to issue vacation orders by which the allottee would be required to vacate the premises within a period of a month if the space is required by the ASTC for its own use. Full stop. It is also not in dispute that in the year 2014 itself, the arrangement was changed from the existing arrangement to be one under a license, and accordingly, license were issued to the petitioners, that too for a particular tenure. Full stop. An examination of the clause of the license would show that the tenure was for a period of 3 years from 2014 to 2017, which was extended from time to time. Full stop. That being the position, the present challenge sought to be raised has to be examined from the context of the license issued in the year 2014, as in the meantime, more than almost a decade has passed, and there was not even a whisper, not even a semblance of challenge with regard to change of the arrangement in the meantime. Full stop. The requirement of the land as an exchange with the NF Railway for creating a second entry point to the Guwahati railway station cannot be doubted, is undoubtedly for public purpose, and the petitioners have also fairly conceded to this point. Full stop. What the petitioners are point. Full stop. The argument made on behalf of the petitioners that they are tenants under the Act of 1972 is not acceptable in view of the aforesaid change of arrangement and the contentions made that the petitioners can be treated as tenants at sufferance will not be applicable in the instant case. Full stop. The only point which requires consideration is as to whether any alternative arrangement can be made so far as the petitioners are concerned. Full stop. On a specific query, comma, the learned AG has submitted that such consideration cannot be possible as any such allotment has to be done from the open market, and the petitioners had already got an advantage from running a business from the premises in question for the last more than 2 decades. Full stop. Para. In view of the aforesaid facts and circumstances, comma, this court is of the considered opinion that no case for interference is able to be made out by the petitioners, and accordingly, the writ petition is dismissed. Full stop. Since this court has been informed that the period of notice would be expiring tomorrow, comma, the respondent authorities would be at liberty to take action, which however has to be strictly in accordance with law. Full stop.
Strictly outside.
Will come after 5 minutes.
আমার কি হবে? গৈ আছো ব'লা। Yes, just give us a minute. Yes. Yes.
Wait, please, your lord. Your lordship, kindly see, my lord, there are 4 petitioners here, my lord.
There is some talk of compromise.
My lord. No, no, no. No compromise, my lord. Another
Normally,
issue, my lord, he's my lord, debate with me and another issue, my lord.
no, normally we do not see a smile on Mr.
No,
Mohammed.
no, that's the issue, my lord, you said.
He's always angry,
No, no.
angry young man.
Agree.
Your lordship, kindly see page 7, my lord.
Which writ petition you'd like to take up?
My lord, my petition is 844. Okay.
We'll
eight-
take up 844 first.
My lord.
এগুলা না লাগে, দেখো। এখন লাগে।
844. Your lordship, kindly see page 7, my lord. There are 4 petitioners here, my lord.
Please make a list who's appearing in whose matter and give us to all the petitions. There are, I think, 4 or 5 petitions. How many petitions are there?
There are 5
5.
writ petitions here.
Who is appearing in whose matter?
Yes.
Okay, 844, yes.
Para 7, my lord. Page 7, my lord.
Page 7.
Page 7.
Yes.
para 2, my lord. Your lordship kindly see, my lord, that they are first, these are the 4 Gram Panchayat before your lordship, my lord. Precedents are here before your lordship. So first meeting of their, my lord, this Panchayat.
In 844, there are four Gaon Panchayats.
Yes, my lord. 844, yeah, 4 Gram Panchayat, my lord.
Yes.
The first meeting, 14 to 2019, 14 to 2019, 14 to 2019, and 15 to 2019. And in respect of sale number 4,
Yes.
number 15 number of Sanatoli, Odoripam GP. So that, my lord, your lordship kindly see, my lord. Now, my lord, the impugn order, which I have annexed D at page 23, my lord.
Page 23.
Page 23.
Yes, please.
The governor, has your lordship got it?
Yes.
Please, governor of Assam is pleased to allow the concerned district commissioner or authorized officer of the officiate as the custodian of the property of Gaon Panchayat, Anchalik Panchayat, Jila Parishad for gap period, that is after completion of the terms and till completion of the election process, as election cannot be held within a permissible time limit. This is issued in pursuant to Section 7, Section 35, Section 68, and 125(4) of B of the Assam Panchayat Act 1994. So we are concerned with Section 7, my lord. Section 7, my lord. And 125(4). Now, my lord, your lordship kindly see Section 7 of the Panchayat Act, my lord.
35, 68, 125, 4. 1, Section 7.
7, my lord.
Gaon
the-
Panchayat.
Of the, yes, Assam Panchayat Act 1994.
Yes.
Every, your lordship,
Yes, yes.
every Gaon Panchayat, save as otherwise provided in this act,
Yes.
shall continue for a term of 5 years from the date of appointment for its first meeting.
Yes.
Provided that, your lordship kindly see that proviso, the term of the office fixed under this subsection shall be held to be include any period which may be elapsed between the expiration of the said period and the date of the first meeting of the Gaon Panchayat, newly constituted, in which the quorum shall be present when where a Gaon Panchayat shall stand dissolved. Your lordship kindly see the meaning thereby, the period, my lord.
Yes.
The term of office fixed under the subsection shall be held to include. So during that period, my understanding is that, my lord, your lordship kindly, after those dissolved, my lord, till the new committee comes, my lord, the first meeting of the new committee, during that period include the statutory period. So, my lord, in such situation, my lord, earlier occasion came before this honorable court, and this honorable court giving an interim protection that till the new election comes, so that is not violated the constitution, my lord, because in Constitution 143, he clearly mentioned it 5 years. That period is 5 years. That, my lord, this proviso include, my lord. If your lordship, my lord, applying this proviso, that period, my lord, from dissolution to till new body comes, that is also included in that stipulated period. So here, my lord, that is Section 7, because applying the Section 7, my lord, this impugn order was passed. Now, my lord, 125 for your lordship, my lord. Because in this, my lord, impugn order, they have not dissolved it. They simply taken away the property of the Panchayat to the one man, my lord, appointee, my lord. So your lordship kindly see 125 for, my lord.
125, 4.
My lord. Panchayat Act 125(4).
Yes.
First, Your Lordship kindly see 125. 125 dissolution of Panchayat. If
Yes.
in opinion of the government opinion of the government, a Gaon Panchayat, Anchalik Panchayat, Jila Parishad exceed or abuse the power or not communicated to perform persistent default in the performance of the duties imposed in the under this act or any other law time being forced, the government may, by an order of publishing the official gazette, dissolve the South Gaon Panchayat or Anchalik Panchayat or Jila Parishad Parishad as the case may be. So, my lord, this 125 is applicable when, my lord, the Gaon Panchayat was dissolved on the ground of their default, not performing well. Then, my lord, section 125(4) will come. Suppose some Gaon Panchayat, my lord, they are not performing well, they are default in the statutory duties, then government, my lord, taken away that right, then only, my lord, that 125(4) will come. Your lordship kindly see, my lord. So by applying 125(4), they have taken away the property of the Gaon Panchayat and vested in the to video was appointed. Your lordship kindly see the next order, my lord.
Which provision?
My lord.
What do you want to refer?
My lord, by exercising that power, my lord, they passed another order, that is Annexure 24A. Annexure D1, my lord. Page 24A, my lord.
Yes, please. Yes.
Your lordship kindly that office order, your lordship kindly see serial number 3, the Gaon Panchayat. The Gaon Panchayat, as the 5-year terms of Gaon Panchayat, Anchalik Panchayat and Jila Parishad is over and in pursuance to the government notification dated 2020 as per provision of the section 125(4)B, the Assam Panchayat Act 1994 exercising power under upon the section 138 of the Assam Panchayat Act, the following officials are allowed to officiate the custodian of the property of the Gaon Panchayat, Anchalik Panchayat and Jila Parishad with immediate effect. Gaon Panchayat, my lord, BDO. Now, my lord, BDO has been appointed, my lord, to the custodian of this property. So that my submission before your lordship, 125(4)B will not applicable to the case in hand, my lord, because here in this case, because non-holding of the election, my lord, this statutory priority is over, my lord. So in such situation, my lord, earlier occasion, my lord, I have annexed one order also, my lord, and also one judgment I have placed yesterday also. That probability is there. So that's why I paid before your lordship, my lord. They cannot keep it, my lord, for an indefinite period, my lord. So during this period, my lord, let this, my lord, Panchayat will be continued without any financial power, any major decision, my lord, as passed in earlier, my lord. And my lord, election should be held in a stipulated time, my lord. Because it is a bounded duty of the state authority, my lord, to uphold the mandate of the constitution, my lord. As per 220, my lord, as per my lord 243E, my lord, your lordship kindly see.
Who?
243E, my lord.
Yes.
Two 243E, my lord.
Constitution of India. Yes.
243, my lord. Every Panchayat, unless sooner dissolved under any law for time being in force, shall continue for 5 years from the date of appointed for the first meeting and no longer. No amendment of any law of this time being force shall have been effect of causing dissolution of the Panchayat and any level which in hit infrastructure immediately before the amendment till the expiration of its duration specified in clause 1. An election to constitute the Panchayat shall be completed before the expiry of its duration specific in clause 1, before the expiry of a period of 6 months from the date of its dissolution, provided that where the CL, your lordship kindly 243E sub clause 3, an election to constitute the Panchayat shall be completed before expiry of its duration specified in clause 1. So they have not, my lord, complied the mandate of the, my lord, constitution, and because of their fault, my lord, now this, my lord, it is in that new Panchayat has not come into the exist, my lord. So my submission before your lordship, in such situation, my lord, earlier one judgment I have already placed and one impugn order also I have placed before your lord. So similar, my lord, order has to be passed and protected the petitioners here. That is my submission.
Where are those judgments?
One judgment, my lord, that is your lordship.
You have annexed?
I have a next one I'll did that in team order, my lord. Page 36, my lord. Page 36, my lord. Page 36, has your lordship got it? Page 36. Heard Mr. Ali, learned counsel for the petitioner, also heard Mr. M. Bhattacharya, the learned standing counsel, appearing in response number 1, 2, 3, 4, 5, as well as Mr. N. Bora, learned standing counsel, State Election Commission, appearing for the response number 4. It is submitted by the Mr. Ali that on the subject of constitutional existing Panchayat as against first Panchayat, Anchalik Jilla Parishad after the expiry of the tenure with first time till election is held, and number of petition has been filed. And the court passes an interim order permitting the such body to continue subject to the certain condition imposed therein. He has submitted that the tenure of the petitioner has expired on 23/3/2018. He also submitted that although the petitioner are functioning in view of the order dated 3/3/2018 issued by the Commissioner and Secretary of the Government of Assam, Panchayat and Rural Development Department, allowing the Deputy Commissioner or his authorized officer to officiate as a custodian of the property of the Gaon Panchayat, Anchalik Panchayat and Jilla Parishad after completion of the terms and till completion of the election process. In the consequential order dated 17/3/2018 issued by the Deputy Commissioner, the petitioner may not be allowed to continue. By this petition, petitioners have put the challenge on the aforesaid order dated 3/3/2018 and 17/3/2018. The Ali also produced before the court a copy of the order dated 14/3/2018 passed in WPCC 1374/2018. Peruse the aforesaid order dated 14/3/2018. In view of the above function, factual background, it is considered appropriate to issue a notice in this petition. Issue notice to the motion returnable on 9/4/2018. No formal step with regard to the respondents are called for as they are duly represented. However, extra copies of the petition has been served on the learned counsel for appearing on the respective respondent. Following the said order, it was provided as an interim measure that the petitioner Gaon Panchayat, whose term is expired on 23/3/2018, shall be allowed to function till the constitution of new Gaon Panchayat. However, the petitioner Gaon Panchayat are restrained from taking any policy decision and incurring any expenditure of the fund other than the purpose of payment of salary to the transferred staff and routine function of the office without taking leave of this court. Until further order dated issued by the Commissioner and Secretary of the Government of Assam, Panchayat and Rural Department, and the till consideration order dated issued by the Deputy Commissioner Bhavata shall remain suspended. This will affect the suspension. So that was the order passed in, my lord, in earlier round of litigation in 2018, my lord. And here, my lord, your lordship kindly see, in fact, my lord, although the term of the Panchayat is 5 years, and my lord, in the COVID, my lord, probably 1.5 year totally, my lord, it was defunct. Now, my lord, your lordship kindly see another judgment I have given, my lord, that is Uttor Dhemaji, my lord. Uttor Dhemaji Gaon Panchayat, this is yesterday I have placed before your lordship, my lord, that I read the
मैं क्राइड सुन के जा रहा हूँ देखो मैं असल नहीं कर लिया तो डिसीजन नहीं это असल है yes we have this copy we have
So, my lord, my
what is there in Uttar Dhemaji
Uttor Dhemaji, my lord, your lordship.
paragraph
Uttor Dhemaji. তোমালোকৰ লগত মোৰ কিতাপত ভাগ মই Paragraph 14, my lord.
on 4
One for my lord.
D you had said yesterday I think D or something
Yes, my lord. D is my lord here. It is also here, my lord. D, the Gaon Panchayat, D, my lord, last para, my lord.
yes
The Gaon Panchayat, Anchalik Panchayat and Jilla Parishad whose terms is expired because of the failure on the part of the state respondent, the State Election Commission to fulfill the mandate of the Constitution to hold the election before expiry of this term, there shall be allowed to function till the Constitution of the Gaon Panchayat, Anchalik Panchayat and Jilla Parishad after completion of the election, but they are not allowed to take any major decision and make an expenditure from the fund of the then payment of salaries of the staff and constitution function without permission of this court. E, all the election of the Gaon Panchayat, Anchalik Panchayat and Jilla Parishad shall be completed before 31/10/2007. For compliance of this above direction, this court is of the considered due the impugn notice that is necessary to be set aside. Accordingly, the impugn notice is dispersed and set aside and parties to clear his own cost. So, my this is my humble submission, my lord. That is that judgment, my lord, still like this, my lord. It is squarely covered in our case. In the present, as the present situation is also same, my.
anything else
Yes, my lord.
how do you deal with Surja Fukan
My lord.
how do you deal with Surja Fukan yesterday we had pointed out Surja Kumar Fukan
My lord. No.
No. I'm giving look.
you help him
Oh, that, my lord.
to demolish him don't take this kind of help return the book
So, my
okay you
lord,
have a look at this if
lord.
anyone else want to join Mr.
My lord.
I'll place it, Lord.
Now, before I come to read, let us hear the
Yes, no. I'll place it just.
yes. Who anyone else would like to add something? Otherwise, Mr. Mahanta had covered everything. Adgiri, anything? Mondal, anything? We are supporting Mr. Mahanta. Now, if you have anything extra, only then we'll hear you.
Extra, my lord, I mentioned, my lord, Article 40, my lord.
40.
40 of the Constitution of India. It that stating that the Gaon Panchayat is the self-government, my lord.
Oh, just a minute. Let us have.
Article
Yes.
Organization of Village Panchayat.
Just a minute, please. Article 40.
40.
Organization. Yes.
My humble submission, my
Please
lord.
read.
My lord. Article 40, the
Yes.
organization of the village panchayat. The state shall take steps to organize village panchayat and endow them with such powers and authority as may be necessary to enable them to function as unit of self-government.
Yes.
As the panchayat is the self-government, the government has no power to hand over the liabilities to the other person. This is my humble submission. That was I challenge the impute notification.
Okay. Mr. Mondal, anything new?
My lord, what has been, my lord, submitted by my Planet Senior Counsel, my lord. That is, my lord, endorsed by me. And in addition to that, lordship will find in item number, my lord,
Padgiri for which WPC?
yes, WBC number
Padgiri for
1161,
24
24.
and Mondal,
I am item number 24 and 26, my lord.
WPC
Yes, WBC number 762/24
and,
and my lord 1232/24.
okay.
Now in my lord 1232, lordship will find Hasina Begum, did petition, my lord, that we have annexed, my lord, the apex court order. Lordship kindly see at page 38
Okay, just a minute, please.
in WBC number 1232.
Just a minute. One, two, three, two.
Yes.
Yes.
Their lordship will find, my lord, the order was by the Honorable Apex Court at
Page
page 38.
38.
38. Their, my lord, 243E and 243U has been explained elaborately.
1, 2, 3, 4. Hasina. Hasina Begum. Yes.
Yes. Their lordship will find, my lord, page 40, para 12.
40, para 12.
Yes.
Yes.
Uh, Therefore, we direct the State Election Commission by way of interim order to issue election program without any further delay on the basis of the word as per the delimitation done in concerned local bodies when the election had become due consequence to expiry of 5 years term of the outgoing elected body or before coming into force of the impugned amendment so and so, whichever is later. On that national basis, the State Election Commission ought to proceed without any exception in respect of the concerned local bodies where elections are due and likely to be due in the near future without waiting even for the compliance of the triple test by the state government for providing reservation of the other backward classes. We have no manner to doubt that only such direction would meet the ends of the justice and larger public interest consistent with the constitutional mandate that the local self-government must be governed by the duly elected representatives uninterrupted except in cases its dissolution before expiry of the term on permissible ground. And my lord, lastly, my lord,
No, what are you trying to get from this?
my lord, this is my lord, Panchayat is my lord, local self-government. It cannot be interrupted as held by the my lord, various decisions by the apex court. Now, page 43.
No,
lord-
where is the observation regarding interruption?
Yes. That observation, lordship,
No, and this is not a case of interruption.
yes.
Is there anything laid down that yes, you would be allowed to continue?
Now,
This is
my lord,
only for holding timely elections. In fact,
yes, yes, that's
there
what.
was an earlier decision of Kisan Singh Tomar, I think 2006.
Yes, that has been referred also.
Is it referred?
It is referred.
Kisan
Lordship
Tomar
kindly see
said very clear.
page 39.
I think that was also MP case.
Yes. Page 39, para 6 and 7, that has been referred.
Page?
Page 39.
Yes, Municipal Corporation Ahmedabad.
Yes. Page 6 and para 6 and 7, that has been discussed. Now, my lord, page 43, Lordship will find para 28.
Let us see again 243E.
Yes. 43.
Yes.
Yes. Yes. Now, my lord, page 43, my lord, para 28.
Read 243E.
Yes.
Again, duration.
Well.
Every Panchayat.
Yes. Duration of the Panchayat, etc. Every Panchayat, unless sooner dissolved under any law for the timing in force, shall continue for 5 years from the date appointed for its first meeting and no longer. That's the word. my lord.
Constitution says no longer.
Yes, no longer. But in case of my lord, dissolved,
Now, unless
unless,
dissolved before 5 years,
yes,
the normal tenure is 5 years
5
and
years.
no longer.
no longer. But the section 7 of the Panchayat Act says the intermediate period, my lord, that period,
That will be included in 5 years.
yes.
After 5 years, where is your mandate? Tell us.
Now, 243 is mandate. Election has to be held prior to my lord, expiry.
The tenure of 5 years, where is the mandate to continue after 5 years?
Yes.
The people, they choose you for a particular period.
My lord.
You are not chosen for all times to
Yes.
come. It's a democracy.
Yes.
Their mandate is effective for 5 years, and there are conditions by which even this 5 years period can be curtailed
My lord.
in the occurrence of certain events
My lord.
for which a procedure has been laid down. But normally it is 5 years.
5 years.
And no longer.
No longer.
In view of such categorical provisions in the Constitution.
Yes.
Where do you get the right to say that no, till such elections are held, I would be allowed to continue?
Now, my lord, that has been answered in the my lord, my learned senior counsel has already addressed in a my lord,
That is an interim order, number one.
no, final order also.
Even
final
final order, can it go against the constitutional mandate?
Now, since that order has my lord, attained the my lord, finality, that has
No,
not been challenged.
Order has to be examined with the statute. And this is
Yes.
the constitution, not a statute, it's a constitution.
Yes.
Fountainhead of all statute.
My lord.
And you have not dealt with Surya Kumar Fukan.
Yes.
You have to deal with Surya Kumar Fukan also.
Now, my lord, yes, my lord,
Where
in a,
this issue as a specific issue raised may not be for Panchayat, maybe for municipality. We
Yes.
do not know.
now in Suraj Mahajan case, my lord, that has been decided in the Supreme Court, that is pending also. Now, I have referred, my lord, page 38.
Yes.
That is, my lord, pending before the Honorable Supreme Court. Now, their lordship will find para 38, sorry, my lord, para 28, lordship will find one observation has been made. Page 43, para 28.
Yes.
Yes. May I read, my lord?
Yes, yes.
para 28, we were also informed by the learned counsel appearing for the Madhya Pradesh State Election Commission during the course of argument that some writ petitions are pending before the High Court, in which interim orders have been passed, and that may come in the way of the State Election Commission to notify the election program. In that regard, we make it clear that also direct the State Election Commission must abide by the direction and the observation in the order uninfluenced by any of the order High Court of the Civil Court or in the subject of the election concerned local self-government as the case may be. If any order passed or to be passed thereafter by the High Court or the Civil Court in the state of Madhya Pradesh in this conflict with the direction given by the court, by this court, the same shall be deemed to have been superseded in terms of this order and not to be acted upon without the prior permission of this honorable court.
So this will go against you. Supreme Court says that hold elections in time. If
Yes.
there is any interim order to the contrary, obviously the direction of the Honorable Supreme Court will prevail.
Definitely.
So there is no question of extending the tenure of the earlier existing body.
Now, some interim order has been passed by the Madhya Pradesh High Court regarding the notification like us, my lord, by that is the dissolve as we have challenged here.
No.
Now,
No.
my lord, section 125B.
No. You come to you read the facts. See, what is the challenge? What is the ground of challenge? What is the challenge? Subject matter of challenge.
Yes.
The first two paragraphs. There's nothing to do with appointing. It's not a completion of term. Some amendment was sought to be done regarding the number of words, local bodies. We have, this court has held in a number of cases that even delimitation would not be
Yes.
a ground for deferring elections.
Yes, that is the bone of contention there.
Okay, anything else, Mr.
Yes.
Mondal?
That's must. And this has been pending before the Supreme
But
Court.
have a look at Surya Fukan. Try, assist Mr. Mohanta.
Yes, my lord.
Read from-
Your second case is, my lord, your lordship kindly see probably while deciding the Sujo on, my lord, that was not been considered. That Tomar case has been discussed, my lord. But in your lordship kindly see. That Sujo Kumar open case is, my lord, in respect of the Panchayat, not in Panchayat, my lord. It is in case of, my lord, municipalities, my lord.
Well, the expressions are
My
the
lord,
same.
I understand, my lord, that
I hear it.
no longer, the word no longer is, my lord, that is. But while deciding this, my lord, 2007, my lord, Uttar Dhimaji case, my lord,
Hmm.
that probably, that is, my lord, that,
Okay, we'll come back to you on this issue. Let the AG submit.
my lord,
In your rejoinder, you can, because
My
we'll be relying upon Surya Kumar Fukan. You
my
can
lord.
Take this up. No, it is somebody. That's a piece of something.
At 2 o'clock, Lord.
Is it?
I can start, but it will be interrupted.
If, 5
minutes.
5 minutes.
Yes, Lord.
Maybe you will not need more than 5 minutes.
No, straight away, but I'd like to place some laws.
There is no indication that 5 minutes, it might go against him also. First of all, somebody gets out.
But today, a new issue has popped up, Lord.
Which one?
Whether in Assamese culture, we can go for Bhumi Puja or not.
Bhumi Puja, not Puja.
He said
said
we cannot do. We have to do foundation stone laying. He has become Western, Lord.
Not Western, my lord. Bhumi Puja, it was earlier, I have not seen, my lord.
These are all Sanskrit original. Whether Bhumi Puja or Bhumi Puja,
Court will
that,
not comment on this contentious
no, that
issues
other day, Lordship,
unless you come up in a list
No,
for us.
unless Lordship, the other day, Lordship also went to Kaziranga for the Bhumi Puja.
I did not go.
But our court went. Our,
No,
in Ronghar, Lordship, 3 days ago, there was a Bhumi Puja.
no, now it is termed as a Bhumi Puja. Earlier it was not there.
So
Earlier,
yes,
my lord,
objection, Lord.
No objection, no comments.
So I was asking him, Lordship, whether it is Sanskrit or pretty. Is that Shankardev's thing or the other part. So he have to give us reply during the break, Lord.
Okay.
Anyway, Lordship, now first.
You just tell us your point. We'll hear you in details. What are the points you'll be touching?
My point, first point is that if Lordship is pleased to take my learned senior friend T.J. Mohanta's case, Lordship. Lordship will see the parties, who are the parties here. His whole case is trusting on that Uttar Hemazi's case of 2005. In that case, the Honorable Court found that the Election Commission did not conduct the election. Here, who is to conduct election? The State Election Commission. Whether a State Election Commission is a party here.
Okay.
Because the State Election Committee will have to come before this Honorable Court and have to tell. Because at that point of time, the judgment which he is relying, there was a default on their part. To know that default. Same thing happened in 2018 in the Mongoldo's case. In the Mongoldo's case, the learned single judge found that the authorities were well within its control, that election could not be held because there was the exercise of NRC going on. And
Okay, okay. Can you give hand over the copy of Surja Fukan or the citation?
Surja Fukan's judgment, Lordship, I have the book. 2026 GLR, page 767.
2020.
2026 GLR, 767. Surja Fukan versus State of Assam.
Okay.
And I have found a Supreme Court judgment also on the same point. No longer interpretation.
Okay, we'll come back at 2.
Lord. We'll give a list of books, Lordship, what are judgments which we take. This is the recent one, huh? Recent one. Last one. এই judgment চলবে। পঢ়ক এতিয়া।
ইমানো পঢ়াত না বেলেগ আছে
ৰং ঘৰটোতে ভূমি পূজা পাতিছে।
পাতিব দিয়া নাই
হা?
Huh? Oh.
Rmesh David, Rmesh.
ঠিক আছে। সময় দিব লাগিব। এইটো চাই দিন। তলত দিলে হয়। আৰু অলপ তলত। Yes.
So, in this case, Lordship, they have failed to implement the State Election Commission as one of the party respondents. Now, their whole case is based on a judgment of this Honorable Court of the year 2005-6. But before taking your Lordship to the judgment, let us see the impugned order. Impugned Lordship will find that page.
You are referring to which
Read
case?
petition.
Which one?
844.
Mr. Mohandas.
Yes, Lordship. Noor Nahar Jia. So the impugn order, what they have challenged two orders, 3rd February and 14th February. The 3rd February's order, Lordship,
Page,
page 23, Annex 30.
yes.
The governor of Assam is pleased to allow the concerned district commissioner or his authorized officers to officiate as the custodian of the property of Gaon Panchayat, Anchalik Panchayat and Jilla Parishad for the gap period, that is after completion of the term and till completion of the election process, as election cannot be held within the permissible time limit. This is issued in pursuance of Section 7, Section 35, Section 68 and Section 125, subsection 4 B of the Assam Panchayat Act.
Yes.
Now, if we look at this, and before that, the other impugn order is at page 24A. This is also challenge of 14th February.
Yes.
As the 5 years term of Gaon Panchayat, Anchalik Panchayat and Jilla Parishad is over and in pursuance of the government notification of 3rd February and as per provisions of 125(4)B of the Assam Panchayat Act and in exercise power vested upon the undersigned as per section 138(3) of the Assam Panchayat Act 1994, the following officials are allowed to officiate as the custodian of the property of Gaon Panchayat, Anchalik Panchayat and Jilla Parishad with immediate effect. So these are the officials which are given, and
Yes.
this is issued in pursuance of section 7, 35, 68, 125(4)B, 138(3) of the Assam Panchayat Act.
Hmm.
Now let us see what are these provisions of the Act.
Yes.
Section 7. Section 7 is, Lordship, duration of the Gaon Panchayat. Every Gaon Panchayat, save or as otherwise provided in this Act, shall continue for a term of 5 years from the date of appointment for its first meeting, provided that the term of the office fixed under this subsection shall be held to include any period which may elapse between the expiration of the said period and the date of the first meeting of the Gaon Panchayat newly constituted, in which a quorum shall be present when a Gaon Panchayat shall stand dissolved. So here, if we do not go into the nitty-gritties of the whole proviso, if we look at the thing, then the term is 5 years. And it has, the source of power is from the Constitution provision of 243E. I'll go to that section little bit later, the article. Now next is section 35.
35.
Section 35.
Yes.
It is regarding the Anchalik Panchayat. Now we are concerned about the Gaon Panchayat, so 35 is not relevant here.
Hmm.
Now section 125(4). 125(4) is Jilla Parishad. 125, it
Yes.
is dissolution of Panchayat. So we are not concerned about this also, although it has been inserted in the impugn 2 orders. Both the orders have this provision, but my straightway, my submission related wrong. This has been wrongly inserted. So there is no other meaning can be given. So 125(4)B is not applicable at all. Now coming to 138(3), which is there in the subsequent order. In the first order, I did not find that 138. The for 3rd February order does not have this 138(3). Now let us go to 138(3). What is all about? 138 is delegation of power to the deputy commissioner, sub-divisional officer, or any other gazetted officer. The state government may delegate any of their powers under this act or rules framed hereunder, except where expressly provided to the contrary to any government officer of gazette rank. except where expressly provided to the contrary, the government may delegate all or any of the powers of the deputy commissioner or the subdivisional officer under this act or rule framed thereunder to any government officer or gazetted rank, except where expressly provided to the contrary, the deputy commissioner or the subdivisional officer, as the case may be, may delegate all or any of their powers under this act or rules framed under this act to any government officer of gazetted rank. The delegation of power under subsection 1, 2, 3 shall be an order in writing, and such order may be modified or withdrawn at any time.
Hmm.
So there is a power to the government to delegate some of the officers for the purpose of implementing the act. That is the plain meaning. And Lordship would also read 132, removal of difficulties. If any difficulty arises in giving effect to the provisions of this act, the government may take such necessary actions so long as these are not repugnant to the main objective and provisions of this act. A, the state government may by notification constitute a standing committee of legislatures to resolve disputes arising between district administration and the Jilla Parishad. That is not relevant for our purpose. So these are the relevant provisions of the act, which are little bit relevant for our adjudication purpose. Now, coming to the provisions of Article 243E.
Yes.
243E, it says, duration of panchayat, etc. 1. Every panchayat, unless sooner dissolved under any law for the time being in force, shall continue for 5 years from the date appointed for its first meeting and no longer. So by no provisions of any act or any administrative order, this can be violated. So every panchayat, unless sooner dissolved by any law for the time being in force, shall continue for 5 years from the date of appointment of its first meeting and no longer. In Surya Phukan's case, that has been interpreted. I will place a recent Supreme Court judgment also where that interpretation is there. The 2 and 3, these are not very relevant. Now, the parameteria provision is 243U. 243U, duration of municipality. Because the Surya Phukan's case, Lordship was pleased to deal with the municipal. So that this is a parameteria provision. Every municipality, unless sooner dissolved under any law for the time being in force, shall continue for 5 years from the date appointed for its first meeting and no longer. The same words except the word instead of panchayat, here it is municipality. So this is a parameteria provision. So while interpreting, I will place the judgment. Now, before going to the other judgments, their whole case is that Uttar judgment of my Lord Justice T.N.K. Singh dated of 2006. This is annexed in one of the writ petition.
Yeah.
In journal BB, Lordship will find that judgment.
Yes, we have that judgment.
Yes. In that judgment, Lordship will see, by this writ petition, the petitioner challenging the impugned order dated fluence of the Joint Secretary of the Government of Assam of PNRD, such being the situation, these writs are being disposed of by a common judgment. The impugned order is 29/3/2007. This is for information of all concerned that on completion of the tenure of 5 years, with effect from the date of its first meeting, all Gaon Panchayat, Anchalik Panchayat and Jilla Parishad shall automatically stand dissolved. Upon such dissolution, all properties of the Gaon Panchayat, Anchalik Panchayat and Jilla Parishad shall be vested in the government till constitution of new bodies. However, such automatic dissolution shall not take effect where there are directions and orders of the court. So this was put to challenge. Here there is a reference of Article 243 in paragraph 3. The learned counsel appearing for the petitioner as well as the respondents are of unanimous view that these petitions are to be considered and disposed of in the light of the constitution mandate under Article 243E of the Constitution of India. Article 243E of the Constitution where it says follows, the quotation, it has been quoted there. Then thereafter, section 5 of the Panchayat Act and others, even section 31, 125(1), these are all referred to. State's submission at paragraph 9. Paragraph 10, the State Election Commission, this is relevant. The State Election Commission, by filing affidavit in opposition, gives the reasons for the failure to comply with the mandate of the Constitution under clause 3 of Article 243(3)(e) of the Constitution of India, which are contradictory to the case of the state respondents in their joint affidavit. The State Election Commission in affidavit in opposition state that failure of performance of its constitutional duties for holding Panchayat election as per the constitutional mandate within the period of 5 years were because of the failure of the state government to fix tentative date proposed for holding Panchayat election in the state of Assam. That is ground number 1. The State Election Commission also states in the affidavit that the Assam State Election Commission was established in the year 1994, and since then it has been running under the Directorate of Panchayat and Rural Development Department, particularly in financial matters. Other reasons for the failure of the part of the State Election Commission to perform its duties as per the constitutional mandate to hold election of the Panchayat is because of the failure on the part of the state respondents to release the funds for holding the election. So these are the 3 grounds. Then paragraph 12, Kishan Singh Tomar was also discussed. 13 to 43U has been discussed here. Now, the various arguments were discussed, and finally, what the Honorable Court said. Paragraph 14. From the above discussion and also in the peculiar facts and circumstances of the writ petition, wherein the state respondents and the State Election Commission have admitted their failure to perform their duties to carry out the mandate of the Constitution discussed above, these writ petitions are disposed of with the following directions. But prior to that, in paragraph 13, the principle of service jurisprudence was taken into consideration. That government cannot take advantage of its own default. That is in relation to some service matters. May I read it? Paragraph page 38, top part. It has taken functioning of all Gram Panchayat, Anchalik Panchayat and Jilla Panchayat through their employees till the constitution of new Panchayat. It is well settled principle of law that one cannot take advantage of its own wrong. Reference to be made to the decision of the Kerala High Court, full bench in Kanakku Kumar Pillai versus so and so another case reported in AR 1963, and the decision of Amrit Singh and others reported in AR so and so, wherein the apex court held that if there was any administrative lapses, the concerned employee could not be victimized. So that victimization of employees cannot be equated to the mandate of the Constitution when there is a fixed term of 5 years, when the particular committee loses its authority to continue a day after the expiration of the 5 years. They become functus officio. In that situation, the Honorable Court, on the principle which is relatable to service jurisprudence, has been imported here while deciding a issue which is totally on a different footing. Now, what are the directions the Honorable Court said? The State Election Commission, as contemplated under 243K of the Constitution and the Section 114 of the Panchayat Act, is to function independently of the state government in the matter of their power of superintendence, direction and control and conduct of all the elections to Gaon Panchayat, Anchalik Panchayat and Jilla Parishad. The State Election Commission has to fix date for holding election of all the Gaon Panchayat, Anchalik Panchayat and Jilla Parishad. C. The state governments are to fulfill the requirement of the State Election Commission as may be necessary for discharge of the function of the State Election Commission for holding election to all Gaon Panchayats, Anchalik Panchayat and Jilla Parishad. D. This is what they are praying for. The Gaon Panchayats, Anchalik Panchayat and Jilla Parishad whose terms has expired because of the failure on the part of the state government, and the state election commissions to fulfill the mandate of the Constitution to hold the election before the expiry of their term, shall be allowed to function till the constitution of a new Gaon Panchayat, Anchalik Panchayat and Jilla Parishad after completion of the election, but they are not allowed to take any major policy decision, make any expenditure from the funds other than the payment of salaries of the staff and routine function of the office without the permission of this court. All the elections of the Gaon Panchayat, Anchalik Panchayat, and Jilla Parishad shall be completed within 31st October 2017. These were the judgment. In this case, why I am referring here, the Election Commission came before this honorable court by filing an affidavit and citing 3 grounds why the election could not be held. Now, in my learned friend's case, they failed to implicate Election Commission as a party here. What is the reason why the election could not be held before the expiry of 5 years? That means in February. There is a genuine ground. That genuine ground is discussed in another case which I will cite now. The ground is very clear. I had this discussion with the concerned person shortly. It was told to me that a fresh list of voters have to be prepared because after the delimitation exercise done in December 2023, lot of villages have changed position, lot of constituencies have changed position, districts have been merged, district has been diverted to other places. So a major exercise has to be done for having the electoral rolls. So that is why Election Commission's presence is very much essential in this case, if they want to take advantage of this judgment. Otherwise, this judgment is bad in law. It is totally unconstitutional judgment. If you look at all the subsequent judgment, including Surya Kumar's judgment, Lordship, Surya Fukon's case. So this judgment I am trying to distinguish because they are not bringing the State Election Commission into this proceeding, maybe deliberately. Because of not of financial condition or because the state government is not acting as a spanner for holding election. It was a delimitation exercise done in terms of the Honorable Supreme Court's direction, as well as a constitutional amendment. The Election Commission of India was conducting the delimitation exercise in Assam. And as a fallout, as a corollary of the delimitation exercise done for the parliamentary constituencies as well as the legislative assemblies, automatically the Gaon Panchayat, Jilla Parishad and the Anchalik Panchayat territory has been changed. So new voter list will be required now. That is why the government has already issued a public statement that by August we are going to hold the election. After this general election, there will be an electoral revision. Phase revision will come out for the purpose of conducting Panchayat election, and before August, the election will be over. But these things they are not inviting this fact. For that they have to implicate the State Election Commission. Now, the second judgment which I would like to refer to of 2018, Poob Mongoldoy Anchalik Panchayat and another versus State of Assam. In this case also, the duration of 5 years was over and they want extension. And there also whole basis was that Uttar Dhemaji Gaon Panchayat case, which I have just placed. Here, the learned single judge was pleased to quote the stand of the petitioners, the stand of the state, and also the stand of the State Election Commission. The State Election Commission very categorically stated that they could not hold the election in Assam or for the purpose of Panchayat, because at that point of time, all the government officials were taken for the purpose of NRC duties. May I place your lordship to paragraph 31-32 onward. In the order dated 22/2018, the Assam Public Works, the Honorable Supreme Court observed from the materials on 31 onwards.
Okay. Yes.
Paragraph 31 onwards.
Yes, yes.
In the order dated 22/2018 in Assam Public Works Supra, the Honorable Supreme Court, that is the case related to NRC in the Supreme Court. From the materials on record, it appears that the local bodies, municipal Panchayat elections in the state of Assam is due sometime in the March-April 2018. The said elections will naturally have to be held as per the plans and schedule to be drawn on by the State Election Commission. However, we make it clear that the work of holding the local body Panchayat municipal Panchayat elections in the state of Assam will not be at the cost of upgradation, preparation of the final draft NRC, and that the said work, that is preparation, upgradation of the final draft NRC, will continue as before with full deployment of manpower as on date. It is up to the State Election Commission and the state authorities to take necessary action as may be required for holding the local body municipal Panchayat election in the state of Assam. From the above order, it is evident that utmost priority has to be given for upgradation and preparation of the NRC. The ongoing work of NRC upgradation is not a regular phenomena. Order dated 27/3/2018 of the Honorable Supreme Court had also clearly mandated that the manpower of the state government currently engaged in the work of upgradation of NRC will not be replaced or substituted save and except services of one additional deputy commissioner in his district who may be currently engaged in the NRC work. Affidavit of the State Election Commission, here also the State Election Commission filed affidavit of the State Election Commission reflects that sufficient spare manpower is not available for the purpose of deployment in work relating to Panchayat election. The stand of the state that a sizable section of the government officials and staff are engaged in ongoing upgradation work of NRC is not disputed by the petitioner. On consideration of the materials on record, it does not appear to the court that either the state government or the State Election Commission was not sincere in discharging their constitutional obligations, and it appears to the court that only because of the circumstances beyond their control, election could not be held in terms of Article 243 of the Constitution of India. Pausing here for a moment, Lordship, NRC exercise was taken in Assam after several decades. And the last year's delimitation exercise started sometime in June, July, and was completed in December, Lordship. In that exercise also, it was pending since 2000. In all other parts of the country, except J&K and 4 states of Northeastern region, Lordship, everywhere the delimitation exercise was done sometime in the year 2001. Lordship knows that. And there was an attempt in 2007 also to have the delimitation exercise. Then there was law and order situation. It could not be done. Supreme Court take control of this matter. And finally, the green signal was given sometime in the year 2022 that we have to complete the delimitation exercise, pending for last 20 years. So if the Election Commission had been a party, they would have disclosed everything. Why it cannot be done today and why it was not done during the course of last 3 months. Now coming to Uttar Hemaji, paragraph 34. In Uttar Hemaji's Gaon Panchayat Supra, this court permitted continuation of the earlier elected Panchayat bodies whose term had expired on the ground that the state could not take advantage of its own wrong and that the state had failed to hold the election before the expiry of the stipulated period of time. The fact situation of the present batch of cases is clearly distinguishable from that of Uttar Hemaji Gaon Panchayat Supra. Stop pausing here. And the second ground. Having regard to the proviso contained in Article 243E1, that is 5 years and no longer. So the Honorable Court considered 2 aspects. One is the factual situation is different from Uttar Hemaji to the Mongoldoy case. And also the earlier case, Lordship, the 243 was not properly considered. Here the Honorable Court said, and having regard to the proviso contained in Article 243E1, I am of the considered opinion that it will not be permissible to allow the Panchayat bodies whose term had already expired to continue to function and discharge the powers and duties as envisaged under the Panchayat Act. So the implication of this judgment is that this is a more recent one. It has overruled the earlier judgment. Indirectly, Lordship. Of course, both are of coordinate bench, but here Article 243 has been given a lot of importance. So the Honorable Court come to a very clear and without any vagueness to the finding that I am of the considered opinion that it will not be permissible to allow the Panchayat bodies whose term had already expired, that means 5 years is over, to continue to function and discharge the powers and duties as envisaged under the Panchayat Act. So in that view of them, this case was dismissed. So this
Mr.
Lord
Mr.
Samadhi
Saik-
has been taken
Mr.
consideration.
Saikia, have you noticed one thing?
Lordship,
This Poob Mongoldoi Anchalik Panchayat case which you are referring now,
Lordship.
which has been decided on 29/5/2018.
Lordship.
I kindly come to Mr. Mohanta's petition at page 35,
Yes,
which is relying upon. Have you got page 35? of-
Page 35, I have got.
This is, there is a order of this court
Yes,
in Sujit Mandal's case.
Lordship.
This is 1727 of 2018. If you check the numbers here, 1727 of 2018
It is there.
is there. Final order, it has been dismissed.
Yes, this is a final
That
order.
is, he was relying on the interim order.
Yes,
It's the same case.
same case. The final, ultimately, when the case has been decided, we have to go by that ratio.
Obviously.
Interim order ratio is never considered. If you want concession lot, still I cannot.
No, that is not in my lord. This was my lord dismissed on another ground, my. It is my lord, in that case, my lord, what happened by this time, my lord, they have election was in hell.
No, but
That your lordship kindly said they take
Paragraph
time to. my
34,
lord-
last three lines.
Honorable court took into consideration 243E article.
My lord,
And
I,
the importance of an interim order gets obliterated or it gets merged with the
so, but
final order.
earlier case, my
You
lord,
should
it
have
is-
at least given the final order
my
when
lord,
the matter has been decided.
when the interim order is operating and they have already, election was held.
But you have not disclosed that this matter has been disposed of
My
in
lord,
your petition.
no, my lord, I placed the judgment, my lord. I placed that,
Which-
that I annexed for the interim, yes, that is true, my lord. But
Where have
that
you stated
judgment, my
that
lord, the judgment,
this petition has been dismissed?
no,
You
your
have not
lordship
said
kindly, my lord, if your lordship, my lord, in that proportion, your lordship kindly see the judgment, my lord.
which judgment?
The judgment which was referred, my lord, Pub Mongoloi, my lord.
Yes.
Pub Mongoloi, that was in fact, that was in the first day of the motion, it was placed before this honorable court, my lord.
By whom?
By us, my lord, before the another court, my lord. And that they have taken, then they have taken the time to file a affidavit, my lord. Look, I have annexed the
Where is the
interim, my lord.
reference? We have there is no reference of Poob Mongoldoi.
No, my lord, this is an individual case, but ultimately all are decided in a that's common judgment.
No, it's okay. But this you are relying upon an interim order
My lord,
passed in the year 2018, 26/3/2018
my lord.
in one of the writ petition, and that is one of the writ petition which has been dismissed by a final order. There is no reference of the final order in your
Yes,
pleadings.
that is true. That is reference of that final order, but that is a reported judgment, my lord. That reported judgment was placed before, my lord, the time of motion, my lord. And that, my lord, your lordship kindly said dismiss, my lord. Why? Why dismiss? It is dismissed, my lord. Why this it is becoming infructuous, my lord?
Okay, we'll come back to you. Okay, then again,
Yes.
yes.
Now coming to the Pukan case. Two thousand 26 SCC, I placed 243E and 243, the other relating to the corporation, municipal case also. So this is relating to 243U regarding the municipality. The principle is same, the wordings are same, the whole sentence is same except the word Panchayat and municipality are interchanged. In this case, lordship was
Okay. Sorry, yes.
first paragraph, lordship. The subject matter of challenge of these two writ petitions being similar, the same are disposed of by this common judgment and order. Petitioner herein have to put challenge and order by which the expiry of the term of the municipal board, it was provided that the charge should be handed over to the deputy commissioner and subdivisional officer civil. Further prayer made in this petition is to allow the petitioners to continue in their positions in their respective municipal board till fresh election for the same is held. Same prayer, same situation, except the entity. All these cases, lordship was pleased to discuss, including Kishan Singh Tomar, Bhanumati. Lordship was pleased to quote everything of the relevant laws. I was a part of the adjudication as a amicus curiae, Lordship, paragraph 18.
Okay, yes,
May I put that submission?
yes. Mm.
The learned senior counsel has assisted this court as an amicus curiae. In this regard, reference has been made to an order dated 5/8/2020 by which this court had directed registry to show the name of so-and-so as amicus curiae. This IKEA learned amicus curiae has drawn the attention to the prayers made in the writ petition, so-and-so, which are firstly to set aside the communication dated 31/5/2020, and secondly to allow the petitioners to resume as chairman of the concerned municipal board, that they want resumption. According to the learned amicus curiae, the notification dated 31/5/2020 is without any statutory backing, inasmuch as section 26(5) of the act has been struck down. At the same time, direction to allow resumption of office of the chairman by the petitioner will be against the mandate of section 26(1) of the act and article 243(u) of the Constitution of India. Reference has also been drawn to the provisions of the 6th schedule to the Constitution of India, more particularly paragraph 2(6)(a). It is submitted that proviso empowers the governor to extend the tenure of the council under certain exceptional circumstances, specifically dealing with the provisions of article 243(u). It is submitted that there is no scope for extension of the term of the municipality, and in the present case, the election could not be held because of the outbreak of the present pandemic of COVID-19. It has also been submitted that so far as North Lakhimpur is concerned, a notification was already published regarding holding of election in 5 phases, out of which 2 phases had already been done. By citing the case of Kishan Singh Tomar, the learned amicus curiae had submitted that upon expiry of the tenure, the petitioner becomes functus officio, and therefore the question of extension does not arise. He submits that to overcome the present situation, there may be requirement of bringing out an ordinance. So that was our submission, and finally, Lordship was pleased to give the opinion at paragraph 27-28. On the other hand, this court finds forth in the argument of the learned additional advocate general that in absence of any provisions for extension of the term, the prayer for the petitioners are not tenable. Further, when the statute itself has the power to control over municipalities upon the state, the impugn notification cannot be said to break with illegality. This court also finds forth with the submission of the instant case, the charges had already been handed over by the petitioner, and therefore the writ petitioners are actually infructuous. The submission of the learned amicus curiae that unlike there being a provisions for extension for a term of council under the 6th schedule of the Constitution of India, there is no such provisions so far as municipalities are concerned, identically for Panchayat also are concerned, and rather a contrary provision exists that is also a relevant consideration for adjudication of the case. This court is also of the view that the source of power to sit in the office of municipality is the mandate given by the people as voters, and the mandate is only for the period prescribed in the statute holding the field. This fact is fortified by the expression used by the constitution maker in inserting the word and no longer in article 243(u). In absence of any mandate after expiry of the term prescribed by law, in the opinion of this court, the petitioners would not have any enforceable right to maintain the present challenge. In fact, the very locus of the petitioners to maintain the present challenge would be questionable. The election to the municipals being part of the constitution, which is the cornerstone of democracy, the authority bestowed by the electors upon the petitioners who are elected representatives had ceased immediately upon expiry of the term. Further, both the writ petitions are being filed respectively on 34 and 23/4, by which time the charge of the municipality is admittedly being handed over on 31/3 and 22/4/2020. Respectively, the question of allowing resumption of charge cannot arise. This court has also taken note of the pleadings made in the writ petitions, wherein the principal concern of the petitioner is apprehended denial of basic amenities to the residents of the respective municipal board in absence of an elected body. However, it is seen that such amenities being presently provided by the municipalities run to the administrators, which is more pronounced because of the ongoing pandemic. The apprehension of the petitioners are also speculative in nature and without any basis. Lordship was pleased to dismiss. And the recent judgment on the same line, Lordship, of the Honorable Supreme Court. 2022 Supreme Court Online SC 1489. Hemant Narayan Basne versus Commissioner and Administrator of Pune Municipal Corporation. Paragraph 5. The High Court, after a detailed survey of the relevant provisions, found that the suggestions made on behalf of the appellants devoid of substance while observing inter alia. First and foremost, it is required to be noted that there is no.
You're reading which paragraph?
I am reading paragraph 5. Here, the basic facts, Lordship will find that first paragraph.
Yes,
May I read it?
yes, please.
Paragraph 2. By the way of this appeal, the appellant had questioned the order dated 29/3/2022, whereby the High Court of Judicature of Bombay has dismissed the writ petition filed by him while asserting his capacity as the chairman of the Standing Committee of Respondent number 2, Pune Municipal Corporation, and seeking relief essentially to the effect that, irrespective of the expiry of the term of the corporation, the Standing Committee shall nevertheless continue to function, and the order issued by the government on 3/3/2022 appointing an administrator does not forbid the Standing Committee from functioning in accordance with the provisions of the Maharashtra Municipal Corporation Act 1949. So this order has been quoted. Tenure is over here. Paragraph 4. The case of the appellant is that on 24/2/2022, the program for election of the new chairman of the Standing Committee of the corporation was announced, and the election conducted on 4/3/2022. In that regard, he was duly elected as the chairman. The appellant made a representation on 10/3/2022 to the effect that, in existence, until constitution of the new Standing Committee after general election, his representation has replied by the government on 14/3/2022 with reference to the provisions contained in Article 243U of the Constitution of India and Section 6A of Act of 1949, while stating that the proposition of the appellant was inconsistent with the applicable provisions of law. Feeling aggrieved, the appellant preferred a writ petition that had been dismissed by the High Court by way of its impugned order dated 29/3/2020. The High Court, after detailed survey of the relevant provisions, found the suggestions made on behalf of the appellant devoid of substance while observing inter alia as under. First and foremost, it is required to be noted that there is no provisions under the Maharashtra Municipal Corporation Act 1949, which says that notwithstanding the tenure of the corporation coming to an end, the Standing Committee of the corporation continues to exist and function as a standing committee. It is well settled principle in law that the court cannot read anything into the statutory provisions which is not provided therein. Article 243U1 of the Constitution lays down every municipality, unless sooner dissolved under any law for the time being in force, shall continue for the 5 years from the date appointed for its first meeting and no longer. Similarly, Section 6(1) of the Maharashtra Municipal Corporation Act provides that every corporation, until sooner dissolved, shall continue for a period of 5 years from the date of appointment of its first meeting and no longer. The word "no longer" used in Article 243(1)(u)(1) of the Constitution and Section 6(1) of the Maharashtra Act thus mandate that the duration of the corporation can only be for a period of 5 years, and there can be no extension to the tenure of the corporation. Section 6A of the Maharashtra Municipal Corporation Act stipulates that the term of the councillor shall be coterminous with the duration of the corporation. On a plain reading of the above provisions, there can be no manner of doubt that upon the duration of the corporation coming to an end, a councillor ceases to be a councillor. Once a councillor ceases to be a councillor, we do not see how the Standing Committee, which comprises 16 councillors, can still exist and continue to function as such, and it is the administrator who is appointed exercises the power and function of the corporation. The entire emphasis of the learned counsel for the petitioner is on the proviso of Section 23 of the Maharashtra Act, which states that all the members of the Standing Committee in the office shall retire from office on the election of new committee under subsection 2 of Section 20, the submission of the learned counsel entirely overlooked the present situation. Finally, the opinion of the court is that it was
Paragraph.
upheld the Bombay High Court judgment.
I think paragraph 20 makes it very clear.
Yes, sir. When it is apparent that the duration of the corporation itself is for a period of 5 years and no longer, as per the mandate of Article 243 Q1 of the Constitution, duly reflected in Section 6 of the 49 Act, the term of the office of the councillor has specifically been provided to be coterminous with the duration of the corporation in 6A. Then the standing committee is to be consisting of 16 members. We are unable to find any logic in the submission made by the learned counsel for the appellant that even if the term of the corporation comes to an end, and even when the term of the office of the councillors comes to an end, yet the standing committee as existing on the date of completion of the terms of the corporation and councillors shall continue to be in office until composition of the new committee after election. When no person could be said to be holding the office of the councillor after completion of the term in view of the mandate of Section 6 and 6A of the Act of 1949, it follows as a necessary corollary that the standing committee stands dissolved along with the completion of the term of the corporation. So there is no doubt about that, Lordship. So whatever was laid down in the Studio Fukan's case, same is here also. And the Honorable Supreme Court also upheld the same. So in that view of the matter, so far as my learned senior friend's case is concerned, Lordship, so there is absolutely no material. They have, if they want to take advantage of the Uttar Hemaji's case, Lordship, they have to make out a case that state government has failed in some corner, which they have not even made an attempt also. They simply want, their prayer is very interesting. They are not having any prayer for having the election. They only are being agreed by 3.2 and 14.2 impugn notice.
Let us see.
Paragraph page 13. Let us come to page 14.
1/4.
1.4. They wanted read in the nature of mandamus or certiorari should not be issued for setting aside and quashing the impugn notification of 3/2/2024 issued by respondent number 1 and consequential order dated 14/2/2024 Annex 30, if any, and allow the petitioners elected body to function of their Gaon Panchayat till new Panchayat bodies are constituted. So they want that they should be continuing till the new election is conducted. There is no prayer for directing the State Election Commission to hold election also. So that is their prayer. And the interim, they want stay of these two impugn notifications. The law is well settled. They cannot take benefit of a judgment which apparently is deemed to be overruled in 2018. Because the first judgment, there was no consideration, although quoting of 243E is there, but there is no discussion on that. When the Constitution does not permit extension of tenure, in so far as the 6th Schedule Area Council, there is a provisions for extension. But in case of Panchayat, municipalities, state assemblies, parliament, there is absolutely no provisions for extension. So 6th Schedule, the governor can exercise that power in some emergent situation. So the constitutional writers, they are well thought of about all these provisions. And unless there is a challenge to the constitutional provision, Lordship, we are bound to follow whatever is there in black and white in the existing constitution. So So this Noor Nahar Diaz case, Lordship, that is my submission. In the other cases, they have made the State Election Commission a party. I leave it to your Honorable Court, whatever ground the State Election Commission brings, once their 5 years tenure is over, and there is no scope for any extension in the Constitution, as well as in the Parent Act also. This Honorable Court, in my humble submission, has already decided the issue, that there cannot be any mandamus to allow them to continue further. So in that view of the matter, Lordship, it is a fit case for dismissal, and I'm not paying for posting of any cost. This is my humble submission.
Yes.
My lord,
One more judgment, Lordship. The recent judgment of the division bench of this Honorable Court, 2021 1 GLR, 2021 1 GLR, page 783, Ratia Bordole versus Assam, State of Assam. Here, paragraph 12.4. 12.4 says, we have already held that the discretion to be exercised by the governor under section 7(3) of the Act is to be exercised during the subsistence of the term of the governing council, as the extension of the term will mean only continuation of the term by way of extension. Once the term of the general council has lapsed, the members of the general council will become functus officio, and the question of extending their term does not arise once they have demitted their office due to expiry of their term. This is regarding an autonomous council matter. So here also they have already given charge to the deputy commissioners or the concerned officers. Yes. Nika.
Yes.
yes, my lord, regarding the Pujapukon case, my lord, that is not applicable to the present case, my lord. Why it is not applicable? First of all, your lordship kindly see that is in respect of the municipality, and municipality is, my lord, 243 EU. So your lordship kindly see that present case, my lord, that is exclusively for the Gaon Panchayat, and Gaon Panchayat rule is something different, my lord. And my lord, while deciding this case, my lord, probably that was also not been placed, my lord. Although the Tomar's case has been placed, my lord, but this earlier judgment of this honorable court was not been placed, my lord. So my submission before your lordship kindly see 243 EU, my lord, in respect of, my lord, 243 EU of the Constitution, my lord.
Yes.
243 EU, my lord. Your lordship kindly see that the duration of municipality.
Yes.
Every municipality, unless sooner dissolved under any law of the time being forced, shall continue for 5 years from the date of appointment for the first meeting and no longer. Provided that a municipality shall be given a reasonable opportunity for being heard before dissolution. So that clause is, my lord, that is not in, my lord, 243E, my lord. When it is in respect of, my lord, Gaon Panchayat, 243E, that is not there, my lord. That is why in Panchayat Act, your lordship kindly see section 7 of the Panchayat Act, my lord. Section 7 of the Panchayat Act. Dissolution of Gaon Panchayat. But here in this case, my lord, by the impugn order, they have not dissolved the, my lord, Panchayat. In fact, they have no power to do this, my lord. Your lordship kindly see, may I read, my lord, section 7, my lord, of the Panchayat Act?
Yes,
Section 7 of the Panchayat Act, my lord.
yes.
Every Gaon Panchayat, save otherwise provided that this act shall continue for a term of 5 years from the date of appointment of its first meeting, provided that the terms of the office fixed under this subsection shall be held, include any period which may elapse between the expiration of the said period and that of the first meeting of the Gaon Panchayat, newly constituted, in which a quorum shall be present when a Gaon Panchayat shall stand dissolved. When it will be dissolved, my lord? It will be dissolved when that, my lord, new committee takes charge and we have even hand over the charge, my lord. That in that it will dissolve, my lord. So that your lordship kindly see that proviso is there only in case of, my lord, Gaon Panchayat. Why? Where this proviso will be applicable then, my lord? Now, my lord, very tactfully, my lord, in the impugn order, they have taken away the property by section 125, which is not applicable to my case. This is admitted by my learned advocate general, my lord. 125(4) is not applicable to this present case, my lord. In impugn order also not indicated that they have dissolved. So this, my lord, gap period is included as a period, my lord.
Just a minute.
So that period is, my lord, that will be taken as a within the period, my lord. That's why, my lord, if I thought that it is a wrong translation, but I have gone through the Assamese version also. Panchayat Act Assamese version also, I have gone, yes, same putting, my lord, same line.
No, this is not translation. This is the act of the state.
Yes, maybe, my lord, that there is a Assamese version also. Maybe,
It's not
probably translate from this one. Probably.
What is there in the vernacular?
And same putting, my.
No, please read.
Yes. অৱশ্যে যেতিয়া এখন গাঁও পঞ্চায়ত ভগ্নাৱস্থাত থাকে তেনে
Read
অৱস্থাত
the first, read this substantial section, duration.
এই আইনত সন্নিৱিষ্ট সেকশন 7
Seven.
গাঁও পঞ্চায়তৰ কাৰ্যকাল আইনৰ সন্নিৱিষ্ট উপবন্ধ অন্যথ নহলে প্ৰতিখন গাঁও পঞ্চায়তে ইয়াৰ প্ৰথম বৈঠকৰ বাবে নিৰ্ধাৰিত তাৰিখৰ পৰা 5 বছৰ কাৰ্যকাল এটাৰ বাবে চলি থাকিব। অৱশ্যে যেতিয়া এখন গাঁও পঞ্চায়ত ভগ্নাৱস্থাত থাকে তেনে অৱস্থাত আগৰ গাঁও পঞ্চায়তৰ কাৰ্যকাল সমাপ্তি আৰু নৱগঠিত গাঁও পঞ্চায়তৰ ফুলৰ সৈতে অনুষ্ঠিত হোৱা প্ৰথমখন বৈঠকৰ তাৰিখলৈ এই মাজৰ কালছোৱা উপধাৰাৰ অধীনত নিৰ্ধাৰিত কাৰ্যকালৰ ভিতৰত অন্তৰ্ভুক্ত হ'ব। So that period will be, my lord, counted as a limited period of just 5 years, my lord. Because normally, my lord, what happened, my lord? Normally, a elected body always hand over the charge to the newly elected body, my lord. So that's why, my lord, that regarding, my lord, case of municipality, there is a provision, my lord. In municipality, my lord, before dissolution, you have to heard the authority, the municipality, my lord. That is, my lord, 243K, my lord, EU, my lord. So, my lord, now, my lord, your lordship kindly see, it is true, my lord, that we have not a major party in the election commission. In the earlier case, my lord, Uttar Dhemaji, in para 14, for that, my lord, your lordship kindly once again look into the, my lord, impugn order, my lord.
Mr. Mohanta,
My lord,
if you read 7, you have to read 8 also.
my lord.
8, you can understand 7 only if you read 8. Section 8, election to constitute Gaon Panchayat. Please read.
Election to constitute Gaon Panchayat shall be completed before expiration of the duration specified in section 7. That is, my lord,
Yes.
that is not, that is to do election commission, my lord.
No, that is it. Before the expiry of the duration, that is before 5 years,
My lord,
you need to hold the elections.
my lord.
That is the first proviso. Second is that in case of dissolution, number B, before expiration of a period of 6 months from the date of dissolution. See, there is a provision to dissolution also, for dissolving the Gaon Panchayat.
My lord,
In case it is dissolved, then you have to hold the elections within 6 months from the date of dissolution. You cannot therefore argue that even a dissolved committee will have the power till the next election is held.
my lord.
Then read this proviso to be there.
Yes, in case of dissolution, no, my lord, here they have not,
read the proviso to be also, provided
provided that whether remaining of the period of
reminder
the
of the
which,
period for which the dissolved Gaon Panchayat would have continued is less than 6 months, it shall not be necessary to hold any election under this subsection for constituting the Gaon Panchayat for such period. See, if the remaining period is less than six months, there is even no requirement to hold an election for that period of 6 months.
no,
It will be a fresh election.
that is, that, yes, and that is in, actually, that is proviso in applicable in case of when, my lord, when Panchayat is dissolved for their own fault, my lord.
Yes.
Then
that-
during that 6 period is not required to hold
So
election.
that both the situations are covered. Number B, let us forget the dissolution part. When a body completes 5 terms, 5 years,
My
the
lord.
duration, what will happen? That if in such a case, you have to hold the election before the expiry of its duration. When the earlier body was functioning, the election has to be held and completed. And therefore, the question of 7 will come. That every Gaon Panchayat has otherwise in this shall continue for 5
my lord,
years
I'm
and this
just-
proviso part.
But proviso party is, my lord, that is then when this proviso party will be applicable. my lord.
Because the elections aren't required to be held within the during the tenure of the earlier body. Not even held, it has to be completed. Now, in a given case, it has not been held, not completed. What will be your right? Can you continue?
No, I'm not on that, yes. That legal mandate, as per the constitutional mandate, they are upholding the constitutional mandate. to
let-
go-
let
but
us go-
in their part, my lord, they have not done.
Mr. Mohanta, let us go to something very basic. Forget about the statutory provision, constitutional provision. The people have elected you not for indefinite purpose. It is the right of the people. You are on the seat because of somebody has elected you.
Yes, my lord,
How long? For how long?
for a limited period,
For a
5
limited
years.
period of 5
For the
years.
first meeting,
For the
yes.
next term, they may not elect you. It's up to the people.
My lord,
Mandate of the people. The mandate becomes over on expiry of the term. They can re-elect you. That's a different matter altogether. But you cannot say that, no, I've been elected, I'll be allowed to continue, should be allowed to continue till the next elections are held. No. If
but-
they are not being able to,
but equally,
if they are not being able to hold the elections for some purpose, that will not automatically mean that you can continue. It's their fault. For that, they'll have to face the consequence. That's a different matter. But can you say, no, I'll have to be allowed to continue? Under what provision? Where is your right? Enforceable right?
I agree, my lord. As per
If you
that,
agree, there is nothing to
No.
argue then.
no, your lordship kindly see that, my lord, if they have, my lord, they have hold the election in time by upholding the constitutional mandate, my lord. Definitely, my lord, that will come.
That is the question we are posing to you. In a given case, they have not held the elections in time.
My lord,
What would be the consequence? Will the consequence?
That's why, my lord, I am
Taking
taking I place the case before, the case that Uttod Hemaji case before your lordship, my lord, because that is in such situation, my lord, that is dealt by this honorable court. That's why I am placing it, my lord. In that, my lord, para 13 clearly mentioned, my lord, that is still appeal, my lord. Maybe, yes, there is another judgment of the another case. My lord, regarding that impugn, that interim order which they have annexed, my lord. I'm sorry that, my lord, that is not in place that finally it was disposed of. Finally, it was
No,
disposed
but
of.
let us not be bogged down by the case law. There is a case decided.
No, my
But-
submission
but
before your lordship, my lord.
what about the constitutional provision, which is a fountainhead of all statute? Says, and for no longer. How do you overcome that?
That's why, my lord, your lordship kindly probably in section 7 of the, my lord, Panchayat Act, my lord, the proviso is there, my lord. No, now even by the impugn order, they have not dissolved it, my lord. They have taken away the property by 125. That cannot be.
There is no question of dissolution after expiry of the term. Dissolution comes when it is within the term, there is some fault of yours, you could not perform, you are incompetent, there has been misuse of
No,
powers.
your lordship
Dissolution.
kindly
It's
see,
not
my
a
lord,
case
this
of
is a,
dissolution.
Panchayat is a
The
local
term
state
is
government.
over. After the term is over, where is the question of dissolution? There's no question of dissolution. Dissolution will have an implication of allegations. There is no question of allegations here. It's expiry of term. Matter ends there.
No, then, my lord, at least, then under what authority government had taken away this, my lord? That has, your lordship kindly see that they were, yes, I do agree with your lordship on that part. Regarding, my lord, all the
Now,
property.
if your case would have been that you have been removed some independent persons of their choice have been given the power to run the panchayat. That is not the case. It is only taking the custody of the properties.
No, by
Till the
virtue of
next
the
election-
125 that is
till
not
the next
applicable.
elections are held. Mr. Saikia has candidly, very
My
fairly
lord.
said that that is wrong quoting. Wrong quoting will not make the
No, my
entire
lord,
action bad.
equally, your lordship kindly see, my lord, can they continue for long period, my lord? They are not respondent authority, not upholding the mandate of the constitution, my lord. So that is also one, but
You
that
have
has to
not
be looked
even-
into, my
You
lord.
have not even prayed for holding timely elections.
And that's true, my lord. Here, my lord.
You are interested in sitting in the chair.
No, sitting the.
You are not interested in facing the elections
No.
also.
I say that till the new election come, maybe, my lord, they can, my lord, hold it, my lord, tomorrow, day after tomorrow, or,
Now tell us very frankly,
my lord.
if we extend it for
No,
5
I am
years,
not paying
for
for
5 years, will you raise the point now to hold the elections in time?
Definitely, my lord.
Definitely not.
Definitely, because, my
Definitely
lord,
not.
because that is their duty to uphold the constitution, my lord. That is their duty, my lord.
At least you should have had a basic prayer that hold the elections in time.
But that is
And
not
if you
there.
don't hold the election, let me continue. You are interested in
Then, my lord, these are law point I am arguing, my lord. It is 243. He is
These
also
are-
not included in my petition, my lord.
The queries of the court are not law points. These are what has emerged from the facts. Okay.
Regarding wrong quoting, Lordship, I just meant that it is well settled that if an authority has power under the law, merely because while exercising that power, the source of power is not specifically referred to, or a reference is made to a wrong provision of law, that by itself does not vitiate the exercise of power so long as the power does exist and can be traced to a source available in law.
Yes.
Section 132 and 138, paragraph 9. It is a settled position of law, Lord. Wrong quoting will not make my action illegal or
And
interfere.
regarding non-holding of the election, my lord, because of the earlier they have taken the plea of NRC. Now, my lord,
Let them come with a PIL for that, will give appropriate answer.
in that case, my lord, although there is not in their affidavit, my lord, he says that there is a process of elimination. The divisional process is concluded in the August 2023, my lord. That is concluded, my lord. And in fact, my lord, Panchayat are not divided. Panchayat are as a whole, my lord, it is included in the new constituency, my lord. না, district to যাব, কিন্তু পঞ্চায়েত তো এটাই আছে না। বলে দিলে
What is the present position now?
The concerned district administration has taken charge.
Taken charge.
Yes. Video in respect of Gaon Panchayat video.
No
That is-
interim order.
No interim.
What?
My lord,
Yes.
my lord, in WPC, my lord, 762 and my lord, 1232, there is a prayer lordship will find.
Yes.
762, my lord, page 20, last line, my lord, or direct the respondent authorities to hold the Panchayat election and constitute the PRI without further delay as per the provision of section 7 and 8 of the Assam Panchayat Act 1994. And or direct the respondent authorities to constitute the committee at the Panchayat level. That must not. That prayer is there in my petition.
762 and what is the other one?
My lord, section 7 and 8 of the Panchayat
No,
Act,
no,
my
no.
lord.
What is the other writ petition?
Other writ petition, my lord, 1232 of the 24.
My case also, my lord. I have a prayer.
Which one? For folding it?
1161, my lord. Council Hall. And I also made a party election, state election commission. My lord.
Okay.
WPC 135203. I have made a prayer regarding holding election paper.
1352.
1352. Paragraph 5.
Read your prayer.
In paragraph, I have specifically mentioned.
Prayer.
In the premises, suppose that it is most respectfully prayed that your lordship may be pleased to admit this petition, call for the record, issue rule calling upon the respondent to show cause as to why a writ certiorari shall not be issued to set aside and quash the interim notification dated 3/2/2014 issued by the respondent number 1 by the deputy by which deputy commissioner or his authorized officials are being allowed to act as the custodian of the property of Gaon Panchayat, Anchalik Panchayat, and Jilla Parishad for the cap period. The rate of certiorari shall not be issued to set aside and quash the interim office order dated 6/2/2024 issued by the deputy commissioner, by which he authorized himself and officers to officiate as the custodian of the property of Jilla Parishad, Hailakandi, Anchalik Panchayat, and Gaon Panchayat. And rate of mandama shall not be issued directly to the state respondent to allow the petitioners to function in their respective position in their respective Gaon Panchayat, Anchalik Panchayat, and Jilla Parishad till the constitution of new Gaon Panchayat after completion of general election in terms of section 7 of Assam Panchayat Act 1994.
Where is your prayer?
After completion of general
Is that the
election.
prayer? The prayer is to continue. Allow it to continue. Don't
that-
make a submission like this. We have read your petition.
Kindly
We have read your petition. You think you have not read your petition?
in paragraph
Paragraph is not the prayer. Mr. Mondal and Mr. Pargiri has a specific prayer. You don't have a prayer. You just suddenly jumped up and said that you have a prayer. You want yourself to be to continue. Show the part of the prayer. Pray for timely elections. If there is, we'll take back our words. There's no prayer. Before you make a submission, don't think that we have not read your petition.
In paragraph, Your Lordship,
Paragraph is a paragraph prayer. Is it the relief you are seeking? Some statements you have made in the petition. Then remove all prayers. There is no requirement. We'll construct our own prayers by reading your pleadings. Don't make the submissions like this. Yes, okay. Heard. Please give, Mr. Mahanta, please ask your colleague to give a list who is appearing in our list. Heard, Sri T.J. Mahanta assisted by so-and-so, so in respectively so-and-so, petitioners. Also heard, colony also heard Sri A.G., Sri D. Saikya, A.G. For all the respondents?
For all the
And election commission, somebody is appearing? I am for the Rakesh Dubey. Rakesh Dubey has become the. Okay, not the Rakesh Dubey. Okay, what is your name? Oh, I think Dubey was here in the morning. Was he there? No. Okay, A.B. Cast. Learned Council.
yesterday he was.
Learned Council appearing on instruction of Sri R. Dubey, Standing Council State Election Commission of India. Oh, and Mr. You are assisted by Mr.
I am assisted by Kumud Poor and Borua. All three.
Okay. 3 cases, 3 assistants. You are entitled to have 2 more assistants. 5 cases are there.
double pay.
Good for them.
Hearing is concluded, judgment is reserved. We'll
I'll
try to deliver as soon as possible.
Lord.
Develop. The lead.
The case in Lok Sabha.
Yeah, please, Your Lordship.
Yes.
In fact, I am feeling somewhat drowsy. I am feeling some drowsy, Your Lordship.
Case is very bad. Before
Your Lordship.
before starting, you're feeling drowsy.
Yeah, Your Lordship. Yeah, matter relates to Your Lordship regarding not non-payment of the actual awarded amount. About 80% of the awarded amount has been paid to us
Awarded by whom?
by the collector, Your Lordship.
Land acquisition.
Land acquisition, Your Lordship. Your Lordship, here, in fact, the land were acquired by total of several land acquisition case for building, Your Lordship, Indo-Bangladesh
Is
border
there,
road.
Mr. Sharma, is there any dispute?
Lordship, according to them, some amount is payable. According to us, after reassessment, that amount is not payable to them.
Yeah,
The rest amount, which is as per our award, that awarded amount has already been paid to them.
You had done a reassessment.
Yes.
And have
No.
you challenged the
yes,
action
yes,
of-
Your Lordship. What happened, Your Lordship, in the first round of litigation, Your Lordship,
Yes.
The respondent have filed a counter affidavit that I have annexed, your lordship, page 46.
Hmm.
Page
There
46,
was an earlier writ petition.
third round of litigation, it is the third
Third,
round.
this is the third one.
Third round, your lord. Before that, your lordship may kindly see page 45, annex 6A. Annex 6A,
45.
45, annex 6A, it is a chart, your lordship, at serial number 2, LA case number 27, 2007, 2008. The original estimated amount, 1,38,994,
Hmm.
out of which 1,68,28,633 was approved and paid to us, which you have accepted, paying for the remaining balance of 26,10,320.21. Now, your lordship,
168 you have received.
yes,
1,68 lakhs.
yes, we have received. In fact, I am representing the entire affected Patadar, your lordship. Now, your lordship,
Now you say that you are entitled to, what is the last column?
last column is the balance. 26,10,321.
No, that is the,
This we are demanding.
no, the original amount is an estimate amount.
Yes,
It
your
is not
lordship.
the approved amount. Approved
I will
amount,
come to
approved amount you have been paid.
approved amount that has been paid. Why I'm also projecting the disparity, because there are some, your lordship will observe that there are also land acquisition case number 4. The first, at page 45, at serial number 1, land acquisition case number 4 of 2006 and 2007. There also the original estimated amount was 1,35 lakh,
Hmm.
48,000 something.
Hmm.
Approved amount was 1,18 lakhs something, and the balance was around 12 lakhs something. That has been paid after, in pursuant to the order passed by this honorable court, your lordship. That judgment I have also annexed, and the payment documents I have also annexed, your lordship. Now, for a moment, your lordship may kindly
Yes.
turn to page 47 of the affidavit filed by the respondent, para 4.
In the earlier round.
First round, page 47. That with regard to the statement made in para 3 of the writ petition, the deponent beg to state that it is a fact that an amount of rupees 26 lakhs 10,321.22 as 20% of deduct compensation as deducted by the government, they have deducted the deduct by letter dated so and so of the said LA case not yet been paid. In this connection, it may be mentioned here that the total estimate for the said LA case was 1,94 lakhs odd and was sent to the government in Form 5 for approval, but the government by letter dated so and so reduced the estimate to rupees 1,68 lakh and approved accordingly after deducting 26 lakhs something so and so, which is also disbursed to land loser interested person. Then your lordship, I will take to the first round judgment, page 50 in WPC 1746/2010. Page 51, fourth paragraph. The state respondent, page 51, your lordship, fourth paragraph. The state respondent in their counter affidavit has admitted the grant of compensation to the tune of grant, your lordship, not only estimate, the grant compensation to the tune of 1,94 lakhs and also of release of the amount of rupees 1,68 lakhs for disbursement of the same among the landowners, including the petitioner. There is no averment in the counter affidavit in regard to non-release of the balance amount of rupees 26,10,321, your lordship. It is there. Now, accordingly, the honorable court was pleased to dispose of the writ petition, your lordship, with the observation made in page 52, your lordship. As the counter affidavit filed by state respondent is silent about the causes for not releasing the balance amount as indicated above, this court find no impediment to issue a direction to the respondent authorities to release the balance amount in favor of the landowners, including the writ petition if they are entitled. Before releasing the amount, the landowners, including the petitioner claim, will be verified, and if found sustainable rather entitled, the amount shall be released with the direction disposed of. Now, Annexure 10 is a similar order in respect of land acquisition case number 4, your lordship, page 54. Hearing your lordship, the direction was something more clear, your lordship. Page 55 is the relevant portion, last two paragraphs. Upon hearing the learned counsel for the parties and on consideration of the written instruction as referred to herein above, reflecting the stand of the respondent, it is considered expedient to close the instant proceeding with a direction to the Deputy Commissioner Kachar to cause necessary steps to be taken to ensure that the balance amount of compensation is paid to the pattadar involved as due to them in law. Needless to say, before final disbursement, the above-mentioned authority would notify the petitioners and release them their dues on proper identification. As the petitioner wait in expectation for nearly a decade after acquisition of the land, the process as directed should be completed within 6 weeks from the date of receipt of the certified copy of this order. Now, all the pattadars of this LA case number 4, they have subsequently paid, and I have also annexed documents of payment. Now, your lordship, pursuant to this order, they pass a speaking order, page Annex 11, page 56. There, please that specifically in this speaking order, please that the land was acquired in 2003. They have done a reassessment in 2007, when practically there was no dealer standing their own, your lordship. And they have made an assumption, no, that the rate was high, and they reduce it, justifying their stand, your lordship. Is it possible? Land was acquired in 2003. They have done reassessment on 2007 when there was no dealer standing there on, your lordship. So it is purely an assumption, your lordship. Now, with that, they have disposed of the matter in compliance of the judgment passed in the first round of litigation, your lordship. Now, challenging this speaking order, we again approach this honorable court. Similarly, in item number 2, they have also appeared, your lordship. The common impugn order, it is a common impugn order challenging both the, your lordship, we file a writ petition being 4-4
Mr. Mazumdar, the acquisition is for what purpose?
for Indo-Bangladesh border road, your lordship,
For a road.
border. Now, your lordship, in the second round of litigation, Annex 16, the judgment was passed, page 63, your lordship. I will take take your lordship to the para 14, your lordship. Having regard to the above controversy raised in the writ petition and also considering the matter in entity, both the writ petition are disposed of directing the LA collector to take into account the aforesaid plea of the petitioners and decide whether
Your writ petition is number 4435 or
yes,
34?
yes,
35
yes.
or 34?
No, 34.
What is your name? Tajuddin?
Tajuddin, 4434.
34, Tajuddin.
And 4435, item 2.
Second
Item
item.
2, your lordship. Now, both these writ petitions were disposed of by a common order, your lordship, directing the authorities to take into account the aforesaid plea of the petitioner and decide whether any review of the order impugned in this proceeding is called for. In any case, the state authority shall pass a speaking order, taking note of the aforesaid plea raised by the petitioners in the writ petition as well as in the additional affidavit. Additional affidavit, we have annexed the payment documents in LA case number 4 to show the disparity, Your Lordship. Let the exercise be termed, let the exercise in term of this order be carried out as expeditiously as possible, preferably within 13 days. Now, I will come to Annexure 17, which is the impugned order. In fact, it is the ditto order of the earlier speaking order of 2012, Your Lordship. Page 17. If Your Lordship peruse
71.
17, page 71.
Annexure 17.
17. Annexure 17, page 71. In fact, it is a repetition of the earlier speaking order. Nothing they have done. Same contention, reassessment done 2007. They have not at all taken into consideration our additional affidavit, our plea, the disparity questions, awarding compensation, the balance of the compensation to the particulars of LA case number 4. This is our case, Your Lordship. In admitted fact, they have also admitted earlier that we are entitled for 20%. There was several communication in this regard, Your Lordship. Even there, Your Lordship, I will also take, in this case, Your Lordship, the respondent number 5 have filed an affidavit. It's very interesting, Your Lordship.
Who is R5?
Respondent is on behalf of Deputy Commissioner, Your Lordship, Land Acquisition Branch. 5. Kindly see, Your Lordship, their page 3, para 6. Para 6. That with regard, even in, they have taken that with regard to the statement made in para 6 of the writ petition, it is a fact, government in the revenue and disaster management department in response to letter dated so and so.
Paragraph are you relying?
Paragraph 6, page 3, inner page 3.
Yes. Yes, please.
That with regard to the statement made in para 6 of the writ petition, is a fact, government in the revenue and disaster management department by letter dated so and so in response to letter dated so and so, in order to obtain view of the concerned department, requested to furnish 1. Statement of fund received from the requiring department. 2. Total amount of fund utilized so far in payment of compensation to land loser LA case wise. Number 3. Amount retained, which may cover the amount required to be paid released what? 20% balance amount. Admitted here. Earlier affidavit also says so. This affidavit also says.
No, this is only the information sought for. This is not an admission.
Your Lordship.
No, your contention so far as the earlier exercise is concerned, that it might amount to an admission, that is
Yeah.
a different aspect.
Only I am
So we'll
projecting,
consider,
yes.
but
It
This
is,
paragraph per se may not mean an admission. He is only asking whether amount of 20%
Yes,
is
yes.
there or not. In
Amount.
case there is a need
retained
to-
which may cover the amount.
Yes.
Amount retained. Why this observation has been given, Your Lordship? I am just projecting that. Your Lordship. I am not stating that even this time they have admitted. Amount retained which may cover the amount required to be paid released toward 20% balance amount. This issue, this question has been raised because earlier there was an admittance, Your Lordship.
Yes, now what do you say?
So my prayer is that, Your Lordship, as they have awarded in LA case number 4, same, what have initially they have done in each and every LA cases, they make a deduction of 15, 20, 25% initially, approve it and make payment. All the affected particular of all the LA cases approach the Honorable Court. In LA case number 4, there was specific direction, and in pursuant to that direction, Your Lordship, the remaining 20% has been paid, your lordship. But in our case, your lordship, the earlier taken in this speaking order again repeated and passed the same order, your lord. The authority cannot take a two different contradictory stand, your lord.
That is all.
I leave up.
Mr. Sharma, we are only on one part. Factual disputes, we may not be in a position to go or will not go.
Lord,
But he's citing that insofar as the first LA case in the serial number 1 is concerned, there was also a deduction. And after a similar attempt by the landowner in that case, where there is a judgment
LA case number 4.
in page number 54, 11/11/2010, that amount has been.
seems to be similarly situated,
Yes,
seems to be.
yes.
But in this case, lordship, regarding the other cases, lordship, I have no knowledge, but regarding this case, it was reassessed. Your lordship may kindly come to paragraph 4 of our affidavit filed by the respondent number 5.
Yes.
Respondent number 5, lordship, that is Paschim Kumar Bhattacharya, has a
Yes,
lordship
yes,
got it.
yes.
Paragraph number 4, that is at page 2. May I read?
Please, please.
That with regard to the statements made in the paragraph 3 of the writ petition, it is not true. It is the fact that the then district collector Kasar in LA case number so and so sent land acquisition estimate amount to rupees 1 crore 94 lakhs so and so only in form 5 for approval. Government via letter number so and so dated 10/11/2005 communicated the approval of the land acquisition estimate amounting to rupees 1 crore 68 lakhs only by reassessment of value of houses and ponds by PWD as per Annexure 1 of the writ petition. The award of the said LA case was approved by the government based on the approval land acquisition estimate. Awarded amount has been released to the partners, interested persons, including the petitioner, that rupees 26 lakhs odd so and so, only being the balance of total compensation amount yet to be paid to the petitioner and other landowners, represented by him, whose lands and jiras, etc., have been acquired by the respondent in the state LA case is not a fact. The petitioner received this payment without any objection. Here we have referred to the Annexure 1 of the writ petition. Now your lordship kindly come to the Annexure 1 of the writ petition, that is at page 32. Yes.
Yes, please.
This is a letter from the Deputy Secretary to the Government of Assam Revenue LR Department to the Deputy Commissioner Kasar Silchar. Last paragraph.
Yes.
The value of houses and ponds are corrected as per reassessment of valuation of houses and ponds by the PW department. Copy and close. So, lordship, this amount is approved after reassessment by the competent authority, which is the PWD. Then your lordships, I think I am able to place the thing before your lord. Then your lordships kindly come to Annexure D of our affidavit filed by.
But he is making a point that the acquisition
Yes,
was
Made in
of an earlier period,
yes.
which is of 2003, and the reassessment was done in 2007.
This letter is of 2005. I am
Five.
placing the letter which is at page 32, Annexure 1. This is a letter of 10th of November 2005. So prior
This
to
is
that,
a five.
while there's this letter which my learned friend is relying upon, where the approved amount and the balance amount was shown, it is done during that period, Lord, 2005, not on 2007.
even 5 after 2 years. 7, somewhere it has been reflected.
LA case number 2003 and.
Now, this reduction of 15%, 20%, 30% as reflected in page
Yes, Lord,
43,
it varies.
these were done upon in all cases after
Regard-
reassessment. Even in LA case number 4, there was a deduction after reassessment, your lordship. Not only in my
Regarding the
case.
other cases, Lordship, I have don't have any knowledge, but
Page
regarding the
43 is there.
regarding the present case I am placing, then your lordships may kindly come to Annexure D of our affidavit filed by the respondent number 5, page 12. This is the order passed in 2012, where also lordship the reassessment,
In your
a
affidavit.
lot. Annexure D, page 12, most probably running page 12. Lord. This is the order sheet,
Just a minute, please.
lordship, lord.
Yes, 21/7.
Yes, 21, sir. I have to read the whole lordship with the 1.5 page lordship. Then from the communication of the chief engineer, file number so and so dated 16/8/2005, referring government letter number so and so dated 12/8/2005, saying that revenue department raised objection for valuation of Jirat. It appears that objection has been raised by the revenue department. The assessment of Jirat value. 3 PK Dev further stated that he has nothing to comment on the reassessment of Jirat value by his superior authority. The executive engineer PWD Border Roads Construction Division, Badarpur Sri Judicial stated that his department has deposited fund for payment of compensation to collector Kasar as per approved estimate received from government in revenue and disaster management LR department. Assam works of border roads construction has been completed, and at this stage he has nothing to comment on the issue. On perusal of the office records, it is seen that while letter number so and so dated 12/12/2005, PWD Border Roads branch forwarded that statement of Jirat, which were checked and verified by the chief engineer PWD building in respect of LHS number 15/2004, 2005 number so and so, and the deputy commissioner Kasar was requested to resubmit land acquisition estimate on the basis of the above verified valuation of civil engineer structures for the LA cases. From the LA case records, it is seen that government in the revenue and disaster management LR department filed letter number so and so dated 10/11/2005. These are all during the period of 2005, lordship. And number so and so has forwarded the approved LA estimate of LA case number so and so. Thus, it is clear that Jirat value was reassessed by the chief engineer PWD building, who is the technical head of assessing our department, and it was accepted by the government in revenue and disaster management department, and accordingly has approved the LA estimate. So that estimate, lordship, that approved amount, the estimated amount on the basis of the the calculation of the Jirats made by the PWD building authority, lord. This is not that then lordship the later part on the basis of that after the litigation, lordship, this part has come. The assets Jirats are no more in existence.
Yes.
So that is prior to that. That later, lordship, where that approved amount and the rest amount was shown, that is prior to that. When the Jirats were there. Now, rest part, lordship, we can skip as because this is at that time there was no Jirat. The assets Jirat are no more in existence on the ground of re-verification as border roads and fence have already been constructed. Also, compensation as per approved land acquisition estimate have already been released to the partners, interested persons, including the petitioners of the aforesaid WPC. Further, the complainant partners received payments without any objection. They have also received that amount without any objection.
Petition is there.
So, this is the picture, real picture, Lord. It was reassessed, the amount was estimated, it was approved, amount paid. Thereafter, they have approached this honorable court. Pursuant to the direction of this honorable court, it was done as because there was no Jirats at that point of time. So, question of making any further calculation doesn't arise. That is our case, Lord.
I will like to add, your lordship. Apparently, the land were acquired in 2003. Even it is 2005, from their document page 12, your lordship. Reassessment was done in 2005. In the year 2005, there were no Jirat standing, your lordship. Already, after 2003, already work started. Even it reflects from the executive engineer who has initially prepared the estimate. As the assessment was done by his senior, he refused to give any comment. He could have stated, I was wrong, nothing like that. And reassessment was done, even if not 2007, 2005, for the time being, I admit it, 2005. In fact, 2005, there was no GRAT, Your Lordship.
Mr. Mazumdar, it is not a case of assessment, reassessment done on existing GRAT. The main, at least on 2 occasions we have come across that the reasons cited is that the buildings and the ponds, the valuation was not properly done as
Done.
per PWD guidelines.
Yes. There was
So
also,
whether the GRAT was an existing GRAT or not, that will perhaps not make much of a difference. It
They-
all depends on what was the guidelines of PWD for making an assessment of a building or a pond. That appears to have been done on a higher side, it was rectified.
that was also done in the case of LA case number, Your Lordship, 4, as I have pointed out, Your Lordship, page 45. or- Sorry, Your Lordship, page, yes, 45, Your Lordship.
Hmm.
There are reference of 4 LA cases.
Yes,
First one is LA case number 4.
that we have seen.
Then, Your Lordship, again, page 41 also, annexure 4A,
40,
41, annexure 4A, 4A. Our case is at 4, serial number 4. Initial appointment, 1 crore 94, paid 1 crore 68, balance 26. And at serial number 1, LA case number 4, estimated amount was 1 crore 35. They approved
Same document.
after reassessment.
that is
Yeah.
the same document.
After reassessment, they have paid 1 crore 18 lakhs. And the balance of 17 lakhs that was paid after in pursuant to the direction passed by this honorable court. So why this disparity, Your Lordship?
His lordship, at that time, what happened in that case? These are 4 different cases. So nature of the cases are same.
One
What
thing
was
can be
placed
done,
at
Your
that
Lordship.
time, lordship, that is not
One
known
thing
to
can
me.
be done, Your Lordship. Let the district commissioner, Your Lordship, reassess all the records properly, Your Lordship. Not pass the last impugn order under challenge, stereotype as passed in 2012. The direction was that the deciding authority should take into consideration our plea as well as what we have contained in the additional affidavit annexing the documents of payment of receipt of in LA case number 4. Let the deputy commissioner, the case may be recalled for reconsideration, taking into consideration all these facts, Your Lordship. This can be done, Your Lordship. Records are with him, Your Lordship.
No, let us see the second order passed in your case.
Second or third order, Your
This is the 3rd round, second order in your case.
second order, so page 63.
65,
Relevant is,
65.
yes, 60. 69 is the 14, para 14. Para 14 is the relevant. Page 69. Having regard to the above controversy raised in the writ petition and also considering the matter in its entirety, both the writ petition are disposed of directing the LA collector to take into account the aforesaid plea of the petitioner and decide whether any review of the order impugned in this proceeding is called for. In any case, the said authority shall pass a speaking order taking note of the aforesaid plea, which has not been done, Your Lordship, raised by the petitioner in the writ petition, as well as in the additional affidavit filed on 22/3/2013. The speaking order that is put under challenge in this writ petition, Your Lordship, has not taken into consideration these 2 facts, Your Lordship. So let the matter be remanded for reconsideration, specifically to take into consideration these two facts, your lordship. And all these are actually cropped up in the first round of litigation where the two different court passed two different types of order, your lordship. Otherwise, we are on the same footing, your lord. Approved amount was made by reassessment of, in all the LA cases, your lordship. It is not that reassessment was done in our cases. Their own correspondences say that the amount was approved, deducting 20-30% upon reassessment.
See, Mr. Mazumdar, it is very easy to criticize this impugned order that since the head of the department has put his views, so he is not in a position to say something else. But what would be the materials upon which he'll make a re-verification? Tell us.
Material verification, they will see.
What are the materials on the basis of which a re-verification can be done?
Their records are already with them.
On
your
what records?
assessment,
The acquisition has been,
initial estimate and the final reassessment report.
acquisition has been done. There are statements that the valuation of the building and the ponds were not as per the PWD schedule.
That is their standing.
Yes. Now, can there be any change in the stand? Even if we remand it back, which has already been done twice. Now, what would be the materials on which a different opinion can
But
be arrived at?
in LA case number 4, they have not taken this stand. Same footing, same case, same acquisition in.
Let us see the order in the LA case number 4.
Yes, your lordship.
Where?
Your lordship. Page 54
Of
WPC 1538/2010.
no, not WBC. We want to see the order by which they have
Ye-
been given.
Yes, yes. Order. There is substantive order passed by this honorable court.
Yes, yes. Other matters perhaps we'll not be able to do. We have to rise early. There is a meeting also. Mr. Roy, Mr. Datta, Mr. Roy Chaudhary, Mr. Goswami is ordered. Which one? Who's for the other side? Oh, he's there. Mr. Sikdar is there. Infractuous. Mr. Sikdar, infractuous.
My lord, I cannot
Yes,
say,
yes, infractuous.
I cannot say, my lord.
Your smile is saying it's infractuous.
My lord, I cannot say, my lord.
We will not record your statement. We'll what is the subject matter?
My lord, they are the builders. They have undergone some agreement with the landowners to construct buildings, multi-story buildings. And the building by law subsequently, my lord, amended with effect from May 2012. And they were not aware of that. They could know only in 2013. But in the meantime, they have undergone an agreement with the landowner, and they are to construct building. They applied for permission as per the earlier rules, earlier building by
You, the
law.
petitioners.
My lord, they pressed for exemption of the earlier rules in respect of those, my lord, the
Ignorance of law will not be an excuse. Heard 3 years Sikdar, Learned Counsel for the petitioners.
My lord.
Also heard Sri S. Datta for Learned Senior Counsel for
From the municipal board, my lord.
who is
Mr.
Silchar.
Lord Silchar.
And who else? Your name? B. Devi, Learned Counsel, appearing instruction of Sri S.P. Chaudhary, Standing Counsel, Silchar Development Board. Mr. Sharma for
One lord.
H. Sharma, Learned Additional Senior Advocate for the state respondent. Full stop. Upon perusal of the subject matter of dispute, and taking into consideration that while proceeding, the petitioners were ignorant of the existing law, which were in fact in operation, this court is of the view that there is no existing cause of action which requires any adjudication. Full stop. Accordingly, the petition is closed.
Obliged.
Sorry for the interference.
nothing.
For a moment, your lordship,
Yes.
in
Mr. Roy Chaudhary?
page 60 and 61.
Just a minute, we'll just,
My
which
lord,
one?
item number 5 and 6. Since 2018 matter, page is stay order operating. I am for the respondent. Can it be day after tomorrow or 19th? Day after tomorrow.
Day after tomorrow. Hearing matter.
That is admission.
Can't say. All matters, okay, we'll try. We'll try.
Yep, yep.
We'll give a date. Mr. Roy Chaudhary?
Seven,
after
no,
tomorrow.
item
Day
number
after-
7.
Seven.
Seven.
Seven what?
Let me on next Tuesday, my lord.
What is the matter?
My lord, because the tender was allowed in my favor, then somebody filed a petition, got a stay order, and my 12 lakhs of rupees is there, my lord. So now I want to get my amount back.
Who's for the other side?
It was forest.
Forest Department. Okay, we'll have it when do you want?
Next Tuesday, my lord.
Next Tuesday? Okay. Next Tuesday. Item number 7.
Yep.
Paucity of time, huh? Paucity of time. Next Tuesday. 19.
Regarding item number 4, man, there is an interim order, man.
Is it limited by time, by today,
My lord,
till today? When do you want? What is the matter?
My lord, matter can be taken up first week of April.
First week of April. On your request, Sri B. Goswami Leonard, AAG, press for a little accommodation. Why first week of April? These are 18 matters.
My lord,
18 matters.
yes, my lord, in fact, this honorable court was, I think, pleased to directly, direct for protection of the record.
No,
Part of
first
the
week of April, 18, first week of April, we'll have it on 22nd. 22nd of March.
22nd of my,
10 days. I think enough.
for my lord, disposal, my lord.
Disposal, yes.
For disposal, first week of April, any date, my lord.
18 matter. We are in 2024,
My lord,
Mr. Goswami.
My lord, then holidays are dear, my lord.
Holy day is after 22nd.
Yes,
We'll have it on 22nd. 22.
22nd of
Praise for a little accommodation. For considering that this repetition is of the year 2018, accommodation is granted. Directive listing of this matter on 22/3/2024. Para interim order passed earlier to continue till the next date of listing.
May I please, the lordship, regarding item number 5 and 6, lordship, there's an interim order in this.
5 and 6, huh? Interim order passed earlier to continue till the next date of listing.
And lordship,
Day after tomorrow, isn't it? Oh.
lordship, small accommodation, lordship, if it can be in the month of April, lordship.
No, there's a stay operating and that's really causing a lot of grievance.
Actually, lordship, we have 2 other matters picked on Thursday.
These are matters of which year?
2018, Your Honor, and the stay has been operating and there's a judgment that's come from this
Okay,
High Court
sorry.
itself.
18 matter. They are objective, so we have accommodated you. Yes,
Obliged, Your Honor.
yes. Mr. Mazumdar.
Lordship,
Mr. Agarwal, which matter? Not
We have-
today.
we are continuing.
Today, in fact, this will also not be complete. We have to rise as a meeting. You tell us which matter of 16.
16, Your Honor.
Day after tomorrow, we'll try. Which matter regarding what?
The matter is very short, my lord. In fact, I can say, my lord, for virtually infructuous.
Other side?
Other side is comment, my lord, what happened in this matter, I'll just take 2 minutes, my lord. If lordship can dispose of the matter, it can be disposed of. My lord, future retails group, Big Bazaar was in Jorhat. Now, some amount of pulses, 35 quintals of pulses were seized. Now, they say that at
What
that
was
point,
seized?
pulse.
Pulses, okay. Hmm.
Pulses is different quantity, rahar dal, muk dal and all that. There's
By the food
by the food
department, okay.
department. Now, the food department is, they are saying is that at that point of time, there was a order of 2022, which says that which item the licensing and other restrictions will be not imposed on that. And it can be, there will be a free movement and all. Without any license, we can set it. For a particular period, which yesterday I was going to, particular period that licensing and other were not
Terms. There was some change in the terms.
changes in all that. They were continuing. They say that you have violated, you have not taken the license. But the order itself says that any order passed by the state government with respect to the items which are covered by 2022 order, they have to take a conference of the central government to impose any restrictions.
That was not taken.
That was not done. Now, food space is, lot of so-called notice and other things were there. Then, since the pulses were there, we said that you kindly give us in demand all that, we can set it out. They didn't give it, they sold it out in option. And ultimately, when the matter was pending before this honorable court, they informed that 1,53,000 and odd was deposited in the treasury. So this honorable court has observed that whatever will be the outcome, it will be decided at that point. Next issue was that we sought for some license. That all right, if you say that license is required, you kindly let us know. We applied for the license. Later on, I have annexed a copy of the letter. They say that since that restrictions is no more now, you are not required to have any license. Now you can only declare your stock to the state government, the Food and Civil Supplies Department. This is precisely the case. Now, my lord, ultimately on the basis of the search and seizure, ultimately there was a, my lord, FIR was closed against the directors and all, my lord, the store in charge and that. Now, against that, my lord, we have already filed challenging all search, seizure and everything. The prosecution sanction we challenge in before a my lord, application under section 482 CRPC that is pending. And this honorable court has stayed the matter. So this is the issue basically. Now, my lord, since the requirement of license is not there, and my lord, in fact, my lord, Twitter retail, my lord, that has been, my lord, taken over by my lord, Reliance Industries and all that, and they are already under liquidation. This Twitter retail is under liquidation.
We'll do one thing, we'll have it day after tomorrow. We'll try to close this.
Huh?
Mr. Sharma?
Let it be disposed of.
Day after tomorrow.
I'll be very short in my submission. My lord.
We have understood your matter. We want to take your views. And because
State government file an affidavit.
we'll not go into the aspects of the criminal proceeding, that is the subject matter of 482. We are only on that period that since even at that time, approval from the central government was required, which was not taken. And the pulses have in the meantime been sold off in an auction. Amount is lying in the treasury. If we pass an order upholding that, they'll be entitled to that amount.
That will be the my lord.
That's the only consequence which is available now.
And so far the my lord 482 it will be decided in.
Okay, day after tomorrow. It will day after tomorrow, Kurjum. Please make a mention. We'll try to upgrade this matter and take it.
I'll take it.
Okay.
May I-
Mazumdar, today it may not be possible. How long will you take?
5 minutes maximum,
No meeting.
even not 5 minutes, 2 minutes.
Okay.
I'm just showing to
Where is that order passed in LA4?
court by this honorable court.
No. Subsequent order.
Subsequent, I have annexed to receipt. That is at page 60.
No, we want to know the consideration. Without knowing the consideration, how will you know that you are at par? Your main trust is that.
Yes, to show the parity, your lordship, disparity, your lordship may kindly see at page 60, your lordship, annex 13.
60.
60. And 61. I have collected 2 payment vouchers. The follow-up order I could not collect, but I have collected.
This we are not. Payment is not we are not too much concerned with the payment part. We want to know the consideration part.
Regarding
the order, this is only a result of the order.
Yes.
We want to know how was that considered. If you say you are at par, your orders are.
In that case.
Your orders are based on some reasons.
No.
We want to see what are the reasons in the other matters.
In that case, your lordship, pursuant to the order passed by this honorable court, no such order or speaking order was passed, your lordship. Straight away they have make payment. I have annexed to vouchers, your lordship. Straight away they have made payment. There is page 60, your lordship. Kindly see in the left-hand side column, your lordship. Certified that one to head of searchable charge. One to third, certified that this is 100% of GRAT compensation, 100%. In LA case number 4 of 2006-2007, and the pay is entitled to get the compensation in DUG number for the amount of rupees, so 1,18,000 after deduction. This was from the balance amount, your lordship, beyond the amount which has been initially approved. There was nothing, no such any speaking order. Straight away, the authority has made payment. Then also page 61. Page 61. Certified that this is 100% of GRAT compensation at village so and so, and the pay is entitled to get the compensation in allegation number 4 so and so, and the pay is entitled to get the compensation for an amount of rupees 33,512. Then your lordship, page 62, why I have initially stated 2007 reassessment, only because of this order, this communication, your lordship. This is a communication of 2007, your lordship. Office of the Chief Engineer, subject reassessment of value. Sir, with reference to the above, I have the honor to inform you that the reassessed value of GRAT at East Liverpool submitted by the executive engineer have been verified technically and submitted here a statement showing the reassessed value of GRAT. Since it is a communication of 2007, that's why I initially make a statement that reassessment of 2007 year. So I'll summarize, conclude my submission, your lordship. When they have made direct payment without passing any speaking order in LHS number 4, the remaining amount, which is beyond the initial approved amount, why this disparity in our case here? The rest I leave up to your.
We will have some more hearing. Or maybe day after tomorrow. Paucity of time. Day after tomorrow. Paucity of time did not allow the matter to be concluded today. No, though hearing had commenced, paucity of time, huh? List for further consideration. Day after tomorrow.
Obligation.
Mr. Sharma, initial order, there was no condition attached by Justice Barua's order, H. Barua's order.
Yes,
First,
Lord. Yes.
you need to just, said no impediment, but at the same time, before you release it, verify it.
Yes, on that verification, that is the order that annexed which I have placed before. your
But
lordship.
substantially, we don't find too much of a difference between this order and Justice Roy's order.
Seems to be.
Yes.
But pursuant to Honorable Justice H. Barua's order, lordship, that order which I have placed before your lordship, that annexed whereby that in earlier lordship, where the GRATs were there, the reassessment was made by the PWD authority, which is the competent authority, and amount was paid according. As after that order, lordship, GRATs were not
No,
there.
since the two more cases are on the same list, so far as 4 is
Seems to
concerned.
be, lordship. Otherwise, but I do not know at that time. what
Reassessment was done
sufficient
in
was
all
made.
cases, your lordship.
But
And
in-
after reassessment, the amount was approved.
In this case,
reducing-
lordship, on specific affidavit, we have
2030.
filed wherein that reassessment part is there. Otherwise, I would not have
Okay.
argued much.
Your lordship.
Much obliged.